Others will mention my lord.
Yeah, pass on the slip. Pass on the memos.
Email and matter is an item.
Yes, sir. Pass on the, he'll see to it. Don't worry. Pass on the memo.
It is in the base. Not mentioning how to buy food. That it's a PIL method that is regarding a supply of fix. Your lordship has twice issued direction for them to file a counter. The tender will end this August end.
Let us see.
Blacklisted person has been given the contract.
Let us see. Let us see. We'll reach. We'll reach. Don't worry.
Item 44 are there in the list.
Anyhow, we'll reach.
Lordship permitted me to make.
If the bar argues 5 minutes for each matter, I am happy. I am happy.
And my prayer is that.
Let us see.
It will be taken.
Let us see.
44.
Yes.
I beg your pardon, my lord. So the one matter.
You pass on the memo, madam.
Yes.
What?
That has to go to another bench. That has to be allotted.
Which
That will
one?
be placed in the administration.
You just.
Yes. In single bench I have passed.
Yes, my lord.
You want that to be listed before any other bench.
Just say it will be sent. Which one?
Item number 59.
60.
60.
Who is appearing?
Defect. Diary and
Diary number, entry number, which will be given a filer number and withdrawn. What is this? It is always done. Yes, call the list.
Test admission item number 1.
Number 1. Gratuity instruction. The Ujo tender whatever done in a split up manner.
Very interesting. This is mandamus or PIL?
Is it villagers are filing?
I am asking you, sir, what is the characteristics of the litigation?
For the interest of the
I am asking you what is a mandamus simpliciter or a PIL?
kind of PL.
Kind of or it is?
It is
It is. Can this prayer be entertained in the PIL? To consider the representation, is it a PIL?
your lordship the gratuity you also directed to take instruction in the matter with regard to the
Mr.
there in
Mr.
provision.
Counsel, it is our PIL rules which says that you file representation. If they don't consider, you file PIL.
Yes.
First they have to consider. You come.
Your lordship.
So we have to decide. We cannot.
Look at the prayer.
And so three is my different.
Can it be? It's a mandamus upon the authorities to consider that representation.
Our rules 10 or 8.
What is
PIL
the
rules 6. PIL. PIL. Have you seen Odisha High Court PIL? Please test that. Rule 8. Rule 8.
It's not a peace. This is against the spirit of the PIL. This is what is actually rules relating to a writ. Mandamus. Not PIL. This is the writ rules.
After receiving the representation, a high level committee is constituted and inquiry is conducted, and inquiry report is also submitted for a committee, monitoring committee. And the monitoring committee is going to have it sitting in the second week of August. The first week of
So the principal grievance is already redressed. Let them take a decision. If the decision is contrary to law, is a contrary to the constitutional mandate, you have a right to challenge it.
Yes.
But we will not keep this matter pending in this regard. Okay, this is the
Whereas in this matter, diagnostic is instruction regarding compliance of the order passed by the county.
Yes.
Or the order that is a case timeless. By instructions that this order was appealed for the order of Supreme Court in SLP zone. And the SLP is disposed of on 13/5/2025.
What?
Yes, this one.
Yesterday,
So-
Mr. Das was citing that judgment. In that judgment, it is covered by virtue of your newly,
Yes, new rules.
new rules, amendment rules, 2025.
25. Delay.
Take a decision. Take a decision. Vidhusagar holds the field
Yes.
along with your 25 rules, amendment rules.
Next,
25 amendment rules is clear. Say, yes, date of death is the.
So instead of pursuing this also, you could have.
next reading, make it practice for that.
When it was dismissed, 12/5, 13/5, what you were doing, now we are on 7/8.
Rule 4 is
Between
violated.
13/5 to 7/8. And there was a direction to dispose of within a time frame.
Within 4 months.
Yes, so now again after 13/5, nearly 3 months is going to be over in just.
That's the accession up to that.
So, I was waiting for that larger rules case.
Wait for 10 days time.
Contempt, no. No. Is a case of a compassionate appointment. A person is deprived of his legitimate right. Will you give that particular appointment with a retrospective operation? Can you? You can't. So if you deprive them of their just right, if I say, then who is responsible?
After dismissal of the session, you must take that full taken place.
Sir, this particular order was passed on 5th of October 2023. Now nearly more than 1.5 years has elapsed.
The end of claim also. At least some.
From the date of application. From the date of application.
They can't give retrospective. We are not saying anything. We're simply recording, fixing the matter after 3 weeks. Let us see the outcome there.
Public.
This contempt application arise
Item number 3.
And requisition for non-payment of the APS amount which has been deposited by the petitioner. Today morning I have taken instruction, some amount there, 3 APS has been placed by the petitioner.
3
APS for additional performance security.
additional performance.
Now 2 has been refunded. That
One is retained.
Returned, for which reason I want to file an affidavit to that effect also, because I have.
Why you have not given? If you have given 2, then why not 1?
Take instruction. He has only paid for this 44 lakh.
44 lakhs.
Out of this, how much is
They
paid?
have not paid anything else. Other costs they have, after filing of the requisition, they have given.
Give it and take instruction.
2 weeks instruction.
Item 4.
Sometimes they say, we have approved the High Court like this. Order come, then we will, or you withdraw that, we will pay.
Is central government, no, sir. I think this matter was taken up on 10th of July and nearly a month time was given to you to take an instruction. So
Para two of the order, last order, para 2 of the last order. My
I've
lord.
seen.
Yes, I'm bringing to your notice. I'm bringing to your notice para 2 of the last order.
Yes, madam.
That is judicial order. Please.
That's why I asked, where is the central government?
I'm bringing to his notice, he must not have seen that.
No, he appeared. Who appeared?
No, see, but he has not seen that. I'm sure he has not seen that.
Yes, madam, there is an order clear for after instruction.
Ah.
With regard to in connection with the affidavit filed.
No, not only that. Certain observations. Shown his inability to appraise the court.
Yes, madam.
So today also the same thing.
Madam, on the last occasion, the additional affidavit was filed by the state government, wherein it is stated for the first time that the application is pending with the central government for diversion of the forest land.
We appreciated your inability and we said that yes, you are supposed to take an instruction that what is the fate of that application. So I think 4 weeks time was I think the reasonable time, sufficient time only to gather one information whether the application is still pending or the application or decision has been taken. We just simply wanted these 2 words from you,
I beg sincere apology.
not even a third word. 2 sentences I wanted.
I beg sincere apology.
And then
We have communicated, but we are yet to receive any.
so let them suffer for that.
Just the 2 weeks time, my lord.
If they are so reluctant, if they are so dormant, they do not care that what happens in the court. Let them.
I beg sincere apology.
Court cannot.
On behalf of
The court cannot be a mute spectators because you have discharged your duties by communicating the order to the authority and the authority is reluctant. The court cannot function in this way.
Make sincere apology, my lord, for that.
How-
I'm seeking for 2 weeks time, my lord. I personally.
Are you sure that a authority who could not respond within 4 weeks will respond within 2 weeks?
I ventilate the displeasure of this honorable court, my lord. Just 2 weeks time, my lord. I beg sincere apology on behalf of the department.
We simply wanted that what is the fate of that application and you will not be able to communicate that what is the fate of the application, whether pending or disposed of. These 2 words are required.
I understand, my lord. I'm just praying for 2 weeks time. I'll ventilate the displeasure of this honorable court.
Why it is necessary? Why the court will show a displeasure, sir? This is your ardent duty to take a decision. Why the court will show the displeasure? Never. The court is not a place to show for displeasure.
I beg sincere apology.
Only thing is a right of the parties. If it is being dealt in this way, then the court may make an observation and take into account the conduct of the authorities.
That makes sense, sir.
Now, why should you beg apology for this?
Because I am repairing the department.
You have done that.
Despite the specific order passed on 10/7/2025.
I got a submission in item 4. I intervened in the matter and the
We'll consider your application for intervention. Consider. Yes.
Item 5, sir.
I'm appearing for the OBCC member. Opposite item number 8, the work has been handed over. This is the work of Chandigarh. Worship is wanted. Various allegations have been made against the work and the completion of the work. We are filing the detailed counter, my lord. Preliminary counter showing how because the premises were handed over to us on April 25, this April. And thereafter we have started work and we also undertake to complete the work by March 26.
What is this work?
75%
What
of
is
the
this
work has
work?
been completed.
What is this work?
This work is renovation of Chandi Mandir, my lord.
So renovation
Ma
means
Chandi Mandir.
just preservation and the restoration.
Yeah. Along with premises. Completely. My lords, we are not doing it by the EA methods, my lords, like using steel and cement. We are doing it by the traditional temple building methods. We are using chondrolite stone. So we have to call in artisans who take their own time to build the sculpture and the other things which will be there. We have given all the details. The map we have given, my lords. How we have A by 2.
No, I understand, I understand.
And your lordship is aware, my lords, Tuesdays, Thursdays and Saturdays we cannot work because of the devotees.
Use footfall of the
Huge
devotees.
footfall. And my lord,
This
Dasara
completely
is going to come.
new design and new structures are.
Yes, yes. Entire thing, my lord, I have shown it. If your lordship kindly says Annexure A by 2, page 13, my lords. Your lordships, these are all the works we have completed and handed over to the temple authority. That is in green. Green marked areas are all completed. And in progress at site, control panel room.
The light yellow is still not.
Light yellow is still in progress.
The mean, so far as the temple is concerned, it is to be built.
Garbhagruha, my lords, we have already built the design. We will now install it with condylite stone and other things, my lords. The entire thing, it takes, and we have to do it by the traditional temple design. We will not use modern materials.
Who are you?
The OBCC, Orissa Bridge Construction Corporation. This work was handed over to us. If your lordship sees Annexure A by 3, this is the letter of the temple management who has given us the inside premises on 10/4/25. Allowed to continue the developmental work of Marchandi, Markatakchan, 10/4/25. Right side top, if your lordship kindly sees.
Yes.
So on 10/4/25, we were actually allowed to start work within the temple premises. And we also, your lordship may note my submission, by March 26, we plan to complete the entire structure in accordance, because it's being looked after by a technical team. And the plan has been approved by IIT Bhubaneswar. And it is being looked, if your lordship kindly sees Annexure A by 1, there's a technical committee at page 10.
Yes.
Constitution of technical committee to review and verify the design, dimension, stability, applicability, and additional cost for Ma Katakchandi main temple. Dr. Ashok K. Patel, ex-director ASI Bhubaneswar. Dr. Jeevan Kumar Patnaik, former superintendent archaeologist ASI Bhubaneswar. Shri Ashwini Kumar Saptati, Superintendent, Directorate of Archaeology, Odisha. So under them, this technical committee has been appointed. We are working under them. The artisans are also working under them. They are supervising from time to time. So, my lords, that is why we are saying. And Dasara, my lords, for 1 month, Durga Puja, we cannot do any work because the lordship
Ingress into Cuttack and egress out of Cuttack is very difficult.
Yes.
Very, very difficult.
That part, my lords, what happens when there are a lot of devotees?
After Ganesh Puja, virtually we can't.
My lords, the work will start.
The pace of work gets slowed down. I understand. After Ganesh Puja, it will be difficult in Cuttack.
My intervenor application is pending to the lordship.
Who are you?
I am a person having interest,
What interest?
but I am a devotee.
So what, this is a public interest litigation? Who is the petitioner? Petitioner. So what do you have?
My lord, two things I want to bring to notice, my lord. First, the temple construction. The other thing is the road in front.
Who are you to go? There is already a committee. You may be a devotee. You have a right to worship. You have a right to perform your puja. You have a right to have access to the idol. There's no difficulty. How?
Being obstructed, my lord.
What obstructed? If they do not make a construction,
Open addresses. He has engaged counsel.
who?
The person he has engaged counsel.
You have engaged a counsel?
No, sir, my lord.
He's the intervener.
Yeah.
No, he's an intervener. He's not a petitioner. Yes.
My lord, I have a document to show you, lords. My lord.
Yes, that. What?
My lord, there is an agreement between the OBCC and the government of Odisha.
What is this?
Government of Odisha has given an agreement with the.
Agreement, okay, yes.
My lord, this is annexed to my lord.
So whatever, tell us that what agreement,
My lord, whatever has been mentioned in the writ application,
correct?
I am to substantiate because there has been.
So you
many
are supporting the petitioner.
Yes, sir, my time and again.
Now the petitioner who is espousing the cause of the others, the large number of the peoples, if they are monitoring and watching that every these actions are to be taken. Just one thing that has struck me. First thing is that if the structure becomes dilapidated or a ruinous, this is not acceptable to any civilized society person. It has to be constructed either to restore it or to preserve it. If the preservation is not possible and it is to be restored by using it, and then the work is in progress, I think if there are experts who are experts in this regard, if they are monitoring the entire work, I think if there is some little inconvenience to the devotees during a particular hours, that will be taken care of.
It's not about inconvenience, only if it is about road, but in the construction matter, time and again that thing changed.
Now they have come up. They have come up with this, and they are also one of the limb of the government.
Yes, sir.
They are not an independent agency or like a private contractor who has come. They are the one of the limb of the government. It is a duty of the government to see that these monuments, these secret places, that those are to be preserved, maintained, so that the sentiments of the peoples are
Yes, my lord.
preserved. That's the only principle.
Yes.
So what is your grievance? They are doing it. Now they have come.
There is my lord. Once it is settled that this temple will be constructed with this amount and this size, this dimension, that will change subsequently.
What?
Once this size it is changed.
Sir, it may be, as he says, that there was maybe a situations where they wanted a modern technology to be used.
No, my lord.
They say that I will not use the modern technology to construct. I am taking an exercise or doing an exercise to build the temple as it used to be built during those era,
Yes.
when the originally the structure comes. So this is what he says, that we are maintaining it.
Yes.
And that's why the team includes the archaeological experienced persons who are in the helm of the affairs. They are there, they are monitoring, the committee is there. Let them make the constructions. Idol cannot live in a ruinous or a dilapidated structure.
Yes, my lord.
No, I think public spirited person would encourage this.
Exactly.
So let it be done.
But my lord, those temples which are designed to be greater size, those have been built up in a smaller size.
So what?
And that is, there are some dimensions.
Again,
which are-
the dimensions you wanted at that point of time, the dimension and this point of time, that is why it becomes, because you don't know the I say substratum, the soil beneath this, whether it is sufficient enough to cater that particular load if the structure is say 70 feet or 100 feet. It all depends.
Initially it was 4 feet. Now we have to go 15 feet below. They have stated it. on
Both sides
application.
reverse.
Yes, my lord.
Because it is just the adjacent to a river bed. I think so there is some kind of a soil
Soil,
erosion that takes place.
paragraph 6 we have said.
One has to be very practical in that. At least the DT should not face any inconvenience. That's the paramount.
Yes, madam. But that is,
Devo-
those have been built.
Let the devotee face inconvenience, but the DT should not face it.
My lord, yes. The temples which have been built up 2 months before, that is showing cracks and water is seeping.
They will take care of that. That is what they say. Now they are using those technologies. Let us see. If it is not up to the mark, we will definitely take steps against them.
Yes, madam.
But how can you come and impede for so far as the construction is concerned? Let it come. Let us see what happens. Thereafter we'll see if something is wrong. And these is the engineers, the artisans who have an expertise, because nowadays we are dearth of artisans who can do these kind of a structures. All modern technology has come.
The other concern of ours is the road. The road in front of the temple that connects to densely populated sides of the city. On the other side of the city, the temple, there are 10 to 15 colleges, schools, institutions, but stadium. The initial road was two-way road, but now they have constructed a single road. So that we prayed, we have applied to the Five Secretary, he visited the spot, he directed somebody to take care.
But that the administration will take care of that.
Yes,
They
that-
are not responsible. They are simply responsible.
No, that
for
is, that
construction
person is included in this project provision.
I think the roads and all, everything, whatever is given in the
Yes,
project, that will be taken care of. They will not deviate therefrom. If it is not possible, if you want a corridor, then there will be a demolition of the many houses. And many persons have to be displaced. Who are in occupation since last 200, 300, 400 years.
Well, that is not the case, my lord, because there are some space has been additionally taken for the temple. From that, we wanted the two-way road which should be there.
How can it be? The road
correct,
cannot, it has to run across the cities.
Yes, ma'am.
So if there is any intervening structures of any building or a house or something, that has to be demolished.
That
You
is,
have the full stretch. Do you want that the 400 peoples or 600 peoples should be displaced?
well,
For
that
one
is-
person's convenience.
on that spot, that's not the case. It was two-way road beforehand. So that we just prayed,
It was maybe a narrow one.
no, sir.
I do not know what is the situation.
Yes,
So,
that is,
to
that,
my ignorance,
that-
I have,
that
till
will be
date,
prayer,
I have not been able to.
that may prayer, my lord, that may prayer, my lord. That the road be visited by the committee. And there are going to be some questions they have gone.
You are an endowment component. What?
No problem at all.
Have you? They what I understood from his argument is that there must be a two access point, one for entry and another for exit. So that there will not be any stampede in the event there is a large gathering of the units. So we wanted the two ways to be constructed.
Two ways. The only thing is he wants the road in front of the mandir to be widened.
Right.
That, my lord.
Not wider, my lord, it is wide.
There are three ways. Three ways.
That will encroach upon many structures.
In front of Marchanti, Mandir is the women's college.
The women college has to be displaced.
No, my lord, that is
Campus.
some land has been added.
Lands were taken off due to the time of
The land which was available was taken.
Yes, yes.
If more land is taken up, then the structure has to be removed.
More land not necessary, my lord.
College, out of certain portion has been acquired and now.
Yes, actually. Actually.
That is, my lords, the city administration or the works department will be taking care of it. We are taking care of the temple only.
What that land of the college was used for, what purposes that should took it for parking,
For the expansion of the road.
for
The
what that land was, whether that land was being used for what purposes that college was using that. It is a vacant land, but it must be for some purpose.
It was within the boundaries of the college, and that was being used by the for playground or something.
I was expecting, this answer I was expecting, that's why I put.
For hostel and
Correct. So the facilities which the students of that college were enjoying,
yes.
everybody wants to curtail that facilities, that these students do not require any kind of a recreation playground. It's not, they will go study and come back. Don't go for any kind of a sports activities. I appreciate. certain things which is out that stress. And the sports activities is one of the planned activities, so, but they excluded us. Are de-stressed. Squeeze the college into this, only one building for study purposes. Others. They do not require. They are very responsible person of the society. They do not want their children to play there, only to go and study in the college. What is the use of giving a recreation or being grounds to the children? Students, they don't require. They believe so.
Prior to that, the temple premises has been extended to, with additional, I mean, the road premises have been taken away by the temple. That you want the temple, which has been enlarged with some additional land, some portion can be given to this road, so that the road can be wider. No need of demolishing the wall of the college.
In care of that.
Yes, ma'am.
If it is visible within that particular availability, they will definitely do it, refurbish it. There is no difficulty in this regard, but for the purpose of widening of the road, many families are
No,
displaced,
that,
the colleges are squeezed into a very smaller portion.
that is not the
Look
case,
at
madam.
it.
Well, we are
Is it-
already we have appealed to the CDA vice chairman. He had assured us, but subsequently it has been done without taking, ignoring this.
Just see if there is a possibility of making the road wider at a particular juncture, which I believe to be.
Yes, Madam. If we get the scope, we will ask the government because we cannot do it. Work has to be executed by the government or through other contractors. They will engage to the works department.
You had.
Well, we have been allotted the work of the temple, madam. So if there was a road, madam, they can do it. There was a.
The public interest decision. but we are not fixing a date.
I'm obliged. March 26th is per chance. That's what all
But if the event if they have, then they can mention the matter, liberty is granted,
Yes.
so that matter will be listed, otherwise it will remain until you complete it. That is all respect.
Yes. Obliged.
Item number 6.
Legal service for minors. One, butcher land minors. Discord minors, organizing land minors, grazing activity. Now minors start.
No butcher. I'm aware of this word.
Yes.
Yes.
Thing is that minors, that is it, page number 18, that I have given the record of right. 3110,
18.
page 18.
Yes.
The 3110, that's the total area of 550 decibel. This is the status of butcher. Minors, what happened? Now minors, the block development officer, without converting it, now wanted to convert constructed minors Kalyan Mandap.
Kalyan Mandap.
Kalyan Mandap. But my
For whose Kalyan?
of the people.
Oh.
But we are not opposing to that. There are various other places also minors which are kept reserved for the purpose of minors use of development work minors that can be done. Earlier also they have chosen a place. And a committee was
What is this Kalyan Mandap used for?
for the purpose of marriage and congregation.
Why you want the person to remain unmarried for all time to come?
There's no question of married or unmarried minors now. All this
You are interfering in their right.
minors knows that even if
Manda.
even if that is not there, can be done. Minors is going up.
No, that.
But it is in a better way, better position, better stuff. Yeah, I'm not on there. I'm not opposing to that at all. Because earlier also they have done it. They constituted a committee. That committee reported it should be considered in another place, minors. That anyway, minors, that was rejected on the ground. It is kept reserved for a school. Though school is running in some other place, minors, that is very much available. But anyway, they have done it. My humble contention is that Gochur is an objectionable land. Minors knows that objectionable land on section 3, minors.
Objectionable land or
Reserve, that's what it is, a reserve land.
Yeah.
A reserve land. So it is objectionable to that extent that it cannot be converted without following the procedure of law. Now,
section 3,
section 3 proviso, 3(1) proviso.
not land reforms.
No, it's not under
These
the
are government land settlement.
government land settlement.
PA.
Second matters that is relating to conversion of not agricultural to non-agricultural farm. So that is what minors refers to under the OLR, Orissa Land Reforms Act, section 80. But here in this case, minors, my humble contention. Other lands are there, they can undertake construction. Earlier also, I have given that copy here.
How many cattle are there for the purpose of?
Yes, sir, most of them are dependent on the minors' agriculture. Most of the villages are dependent on agriculture. That also, I understood minors, so that question might come.
Is only the growing of a grass. It's not for the purpose of
But
agriculture.
with the due humility, minors, with the due humility.
So how many cattle are there in the village?
With due humility, minors, that I have not counted, but I appreciate much for the reason that yes, I also inquired. Earlier, it's 24.
Market complex Nirmanu.
3110, last number.
Yes, 34 man, yes.
Right itself.
Months.
Simply, so and so, plot, so and so. This is one market complex Nirmana.
Market complex, one part market complex, another part Kalyan Mandap. Both each other challenge. They're completely changing the nature and character. Thing is that most unfortunate part is that the block development of the officer managers is authorized to undertake developmental activities. Managers knows that what he does it, he wanted to get it done through their departmental, means through engineer, they are engineer. Tahsildar is the authority managers to allow conversion and to allow the land for that purpose. Earlier manner kind of glass, I'm pointing out very important aspect. Thing is that something is going on there. Must kind of glance to the earlier contingencies at page 23. That is in English, my lord. Page 23.
In English.
That is in English.
My brother is reading many things, so that's why I was thinking.
I don't know, it's there,
All
but
the-
because
all the
what I understood.
Alphabets appears to me the same. That's why.
But fact remains, my lord, so far that the very crux of that revenue was, my lord, might quite consumers.
That is why I'm accustomed with those.
Usually, my lords, after Bengal settlement, our Bengal settlement and all this, we have inherited all those from there only.
Bengal Tenancy Act.
Bengal Tenancy Act, Bengal settlement, that we have inherited all these things from there only. My lords, the thing is that, my lord, kind of close to that. Page 23, yearly year, a Kalyan Mandap was sought to be constructed. So a committee was constituted, site selection committee was constituted. The committee recommended that it should be over a particular plot. Recommended.
That is Lakshmi Narayan.
Lakshmi Narayan. That is Khata number 833.
Khata is different. Plot number 7.
Plot number 797 is another plot.
That is the main plot.
Main plot, another plot. But there that was in Lakshmi, but they have wanted to do it. That is kept for school purpose. That was rejected on the ground that it is made for school purpose.
Correct.
School purpose. Okay, man, school is very important, man, in comparison to any other purpose. But fact remains,
Equally, Kalyan Mandap is also important.
but I don't dispute because it is a development for the purpose of the people. But law should prevail, minus finals. I can't say anything more than that.
If the race does not go on, then what will happen to the people?
But so that is correct, well, that's very correct. But here in this case,
Kalyan Mandap is important.
equally important, I don't dispute on that. But now, as my humble contention, why I pointed out is that managers will appreciate it. Fact remains, school is running somewhere over 2 acres some odd land. This was kept for reservation of school. That is not necessary for that purpose. Anyway, managers, they reject. I refer to for the region. They rejected on the ground. It is meant for school purpose. Here, managers, it is meant for cultural purpose. So there are, but so far as Mauja is concerned, managers knows.
I understand. The one thing that once it is a butcher land, it is now restricted.
Restricted.
Unless you convert that particular purpose, you can't make any constructions, and this operates one of the provisions of the act itself, that you can't use it.
Yes.
So that is why you are saying that how can they use the butcher land for the construction?
Construction of a market complex or Kalyan Mandap.
Market complex. They can't. That is what we wanted to know from how can they.
Lordship, may kindly see page 70. Page
0 or 1?
1, sir.
Can I read that?
Yes, ma'am. The Lordship will find it.
Yes. Can I read that?
Not the
Yes,
entire
that I
thing,
read it,
but
ma'am.
there are some
That is in English.
de-reservation.
No, I do not find 17.
Page
What's the
70.
heading? I do not know. Annexure 1 you are referring.
Annex to 1. Annex to 1.
How can I read?
But that the
Huh?
Khatiyan, that is.
Khatiyan I know.
Khatiyan.
Khatiyan I know. 17.
yes, ma'am.
That is in the name of Mr. Saskar.
That's
विशेष अनुसंग यदि किछि थाए
now can you tell me? I do not know. I just wanted to hear what is the system. The government lands are recorded in a particular Khatiyan.
Government also recorded in a particular khata number.
yes
Under a particular khata number, in a particular mauja, or
It's not picture. There is, I have come from a place, there, what happened? Any land which belongs to the government is always recorded in Khatiya number 1.
so what number 1? So that is
Khatiya number 1. Of the land, anywhere in a Mauja or in a Taluka, anywhere. Whenever it's a government land, it will be under the Khatiya number 1.
it may.
I just wanted to know, is it the practice here also?
No.
That this one number, Khatiya number 1 is dedicated to the government anywhere. You will not find one.
Here in this case, my lord, the proxy, that government is the owner of Khewat number 1. Government is the owner, paramount owner.
Khewat.
But since it is repeated by Khewat number 1. There is no second Khewat, my lord. So far that because all after the abolition of intermediaries, there is no contingency of second Khewat. So then khata numbers are being created mauja wise. One mauja revenue area.
No, it is also, sir. Khatiyan or a khata is only for recording, but there would be one Khatiyan for multiple plots.
For multiple plots. Exactly.
In order to make a person responsible for land revenue.
Right.
That's all.
That's
A person may own several plots,
Yes.
but their own plot will be recorded in
Right,
one
right,
plot.
right. Here in this case, khata number
what
is
number your Lordship will
1418.
find in the second column, second row. Odisha Sarkar Khewat number 1. That is there in that ROR, page 1, annexure 1. The second column your lordship will find.
All the letters are one and the same. Yes.
So, my lord,
Read it, I can't, you just read it, I will understand, I can't.
now, in the middle portion, your lordship will find that in respect of some land, de-reservation process has been initiated
Okay.
or completed. But so far as this particular land, I'll have to take instruction whether they have initiated any de-reservation process or whether it has been de-reserved. So I'll have to take that instruction regarding that.
These are the de-reservation proceedings.
Yes.
Out of this,
Normally it is called as a conversion cases.
Yes.
So you take instruction.
I'll take instruction.
Yes, sir.
Sir,
I was pulling a leg. Like I said.
It's a pleasure, my lord, sir.
Take instruction and come back after 5 minutes.
yes, small favor. In the meanwhile, of course, verbally they may be instructed.
You will demolish it, don't you?
This,
If it is
construction must be there.
not, that power is with us.
Well, that is correct, but to comment money balance, we don't want that it should be. Now it is a very preliminary stage because they want to dig out that area. That is what we could come to know. Because that will take us. That you will give it.
And ensure that if it is not reserved, then in that you have. Yes.
Item 7.
7, my lord, there are two matters. Second matter, my lord, CL is appearing in which second matter, my lord.
First matter, they have not been served with the copy of
My office will serve a copy, my lord.
Who is appearing in the first one?
First matter, my lord, I have been engaged and I will, my lord, ask the
Serve
instructor.
a copy.
Sorry.
Yes, I should. It's not serving a copy.
My lord, yesterday only, my lord.
When it is
Why you hide?
tagged, when it is tagged up, my lord, at least I should know what is the content of that brief.
I am only on the second matter. Deference to my lord.
Not in the first matter.
No, first matter, my lord. With deference, due deference, my lord, friend submissions, my lord. Second matter, if you actually remembers, my lord, it was actually over. I just have to make 2 more submissions and I'll rest my case. Leave it to your lordship. Just 2 more submissions I have to make. This is regarding that aquarium, my lord, where
Oh, sure.
under the
Private.
special terms and conditions, they had said that government or state or central government, and in the detail,
Immediately you recapitulated my
Private
memory.
there was a considerable amount of deliberation on that.
The first matter is.
First matter is relating to the self tender, my lord, wherein my financial bid has not been, my lord, accepted.
Why?
There is no region which has been ascribed, my lord.
No reason is given.
Nothing, my lord. I don't know why my financial bid was not accepted, and they have considered, my lord, the opposite party number
They have
4.
rejected on a technical at the
Hello.
technical bid stage.
Technical
must-
bid, 5 technical bids, my lord, were taken into consideration.
You were there
I was there, my lord.
within 5.
5.
So your quotation must have been higher.
My lord, I do not know the region, but on the other hand, the person whom they have selected,
Oh,
He's
challenging.
he is not meeting the eligibility norms, my lord, of the tender.
He knows better than
And-
you. You are L2.
Yes, I am L2. And the
He
manner,
must be L3 and 4.
and the manner in which, my lord, the tender itself is drafted, it hits, my lord, Article 14, because the fairness goes completely. The manner in which it has been drafted, my lord, the tender norms.
After participating.
Yes, my lord, may kindly see that one.
The participation.
The manner in which, my lord, I participated therein, my lord, no doubt about it.
So after
There are
participation.
contradictory, my lord, tender norms.
Whatever, then why you participate? Why you participate?
My lord,
You know the category of judgment on that.
my lord, my lord, but my lordship may kindly see the other aspect also. I wanted to show it for lordship. Lordship may kindly see whatever you are supposed to deposit, the contract He has not yet given his contract, my lord.
Accepted, it's a contract. Once the tender is accepted, it's a contract. The terms and conditions of-
My lord, the experience, in order to show the experience, he was supposed to, my lord, submit the contracts of whatever he has executed, man. That he has not given also. The opposite partner for my lord.
Was it mandatory? And the-
Yes, my lord. It was mandatory. my lord.
Only.
It was mandatory, my lord.
It's only the certificate
It was mandatory.
or this declaration which is to be.
The eligibility criteria is the proof of all contract related to the maintenance of aquarium. You have to give proof.
That does not mean
Of contracts.
contract.
My lord, proof of contract. Well, how the contract itself, my
Contract
lord,
is for.
between the
There
two
may
parties.
not be a written document. Contract may be oral. The only thing is the proof is required.
Proof is required.
That's all.
He himself
If
is
he
only
can
filing
show
a,
that he has done this work. That's enough.
he himself
That
is only
why
filing a declaration.
certificate is given.
He himself is only filing a declaration, nothing else is there, man.
Just 2 minutes, sir. Friends, sir.
So I understood. You wanted to get away, you wanted to throw out L1. He wanted to throw out for all. So we have to consider.
I just show you lordship that 2 documents. Thereafter, I'll leave it to your lordship. I have submitted what I had to submit on the other day, man. I'll not take much of your lordship's
What
time.
you will do, you will have to fight.
Only two.
They are all interpreting the document.
Yes,
You
sir.
get the copy, but finish it off. I think is a very small matter.
On the face of it,
Very small matter.
I appreciate my level skills matters are concerned, and I'm ready with it, but I don't, since I don't know the contents of the.
If an understanding is ready,
He is saying that the proof of the
On the-
contract must be filed. The second one, he says that the terms and conditions of the tender is unreasonable.
No, I'm not questioning the manner in which the cavalier manner in which the tender documents have been prepared, my lord. Somewhere it says,
Let us see the capillarity of the draftsman. So we have to see. But you participate.
that, my lord, I can't deny
That
that.
you bear in mind. Subsequent action after participation, you can challenge it. When you go at the root,
Both, my lord, is being challenged. Both.
can you, let us bifurcate.
If your lordship holds the view, my lord, that
That's the Supreme Court view.
tender conditions, once you participate, my lord, you can't challenge. Then the second part is non-consideration of mine.
That is what is a step by I say, any action subsequent to the tender.
That can.
That can.
That's the derivative actions.
can I just lordship it bear with me? I just take.
No, I got you. Your point is very simple. So let us hear it. Your point is very simple, sir.
No, that
Law says garments, semi-garments, public, I think public authorities,
public,
not the private one.
not the
He
one.
has submitted a certificate.
There's one more.
Privately.
But there's one more submission. There's one more submission I want to make on the face of it. Lordship, kindly come to the detailed tender code notice. The bidder shall have 1(4) requirement. This is a mandatory requirement, madam. The bidder shall have, page 21, minimum 1 year experience in maintenance of aquarium in the last 5 years. Now, all that, I'll just take in this context, madam, I'll just allude to one document. He has only filed one document for experience, that is one Vanya. In fact, madam, Vanya has worked in a government, he's got the tender in the Raipur government for maintenance of an aquarium. He has offloaded the whole work to him, to my friend's client. Now I'll tell you, Russia, and then there should be a completion certificate, 1 year minimum, that 1 year experience should be there. Your Lordship will see this page 127. Certificate dated 24. Sorry. He gets the work on 2nd of May 2023. The work is awarded to him. The work duration is 1 year. The requirement is 1 year. As per the requirement, we tailor-made to. And the amount is 59 lakhs and odd. Then the next page, my lord, page 127. On 24/8/2023, completion, just 3 months thereafter,
Same authority gives you a completion certificate. Now, this certificate, these are all on face of it. The same 1 year, private. That is why I was submitting one as private concerns. Certificates can be just procured like that. This is a certificate which are to all intents and purposes procured. 3 months, after a 1 year work, we completed in 3 months.
And this is not a construction that you finish it off. It is really a maintenance.
Maintenance work, 1 year.
It cannot be done before 1 year.
Secondly, my lords, the requirement of the detailed, clause 19 of the detailed tender conditions, my learned friend is reliance on. It says that private can also be granted. There, my lords, I would interpret it in this way, that private company, private organization should be owner of an aquarium. That is how. So they have to give it to direct contractors. Here, my lords, Vanya is himself a contractor and he has given it to a subcontractor. And the result is this. They are manufactured. And moreover, my
What is the
lords,
language used?
language is this, my lords, language is this.
Let's say page 19.
Page 19 is the language.
Proof of contracts related to maintenance of aquariums in government, public, private sector undertakings along with during
Private sector undertaking. Maintenance of aquariums in government, ownership of government, in private sector undertaking. Vanya does not own an aquarium. Vanya is a contractor who has been given the work in that Raipur aquarium. That's a page. Clearly, this falls foul of the tender conditions. Page 128. The work order has been issued to by Chhattisgarh State Renewable Energy, who actually is the owner of the aquarium, has issued a work order to Vanya, to Messrs. Vanya Landscaping and Horticulture Private Limited, Raipur, for public fish aquarium and public fish aquarium. He has offloaded that to this.
No, you don't have to repeat. Your lordship may
So
say
he-
a contractor and a subcontractor.
Man, that's that.
One.
That and also 1 year, the minimum 1 year.
That I just to say.
That. So these are the two Banerjee falls foul, clearly falls foul of the tender and this cannot be made up subsequently. And your lordship will see, lordship may kindly appreciate a private concern. That is why we are strongly voicing that if it's a private one, it needs further scrutiny. Because these kind of certificates, they tend to turn up and mothers crop up.
Your lordship may see the same
The
document,
manufacturer.
page 128.
Let him produce, if you have
What my learned friend has said, I will go to the same document, which is the work order.
one more sentence, I'll just have one more sentence for before my learned friend, I'll let him start thereafter. Let him, he has 1 year, he must have completed 59 lakhs of work. Let him produce the TDS certificate. That will seal the deal. Let there be an inquiry, let the TDS certificate be produced. There will be some sort of an inquiry. You can't play fast and loose with the public authorities. You can't obtain a tender like this. Just because an officer is in your favor, you can't get everything pushed under the carpet and accepted. And my lords, and thereafter that come to court and stonewall the attack. That is my submission before your lordship. I leave it to your lordships. This is all public money and this has to get some transparency. Yes.
Lord, the same document my learned friend is showing is trying to completely mislead this honorable. Could your lordship may come to page 128, which he showed himself. If your lordship should see the work details, particulars of the work.
Yes.
If your lordship should come to schedule at 13, serial 13 on that, around just below the middle of the page.
Specified under this work order is to be completed.
Till date 26/2023. So this is not the work order, as my learned friend tries to put it. For the purpose of maintenance, this was for the purpose of construction.
Yes.
And then I take your lordships to page 125, what I had given. Because this is their petition. Well, that's why I said, my lord, if your lordships would see page 125, if your lordships for a moment come to page 19, which I read out, that proof of contracts related to those public sector undertakings and where it included that war. Page 125.
120?
My lord, 125. 125. I have given the details of the,
Yes.
and this has been filed by the petitioner himself. This is what I have submitted.
This is your document.
Yes.
He obtained from.
Forest department is ongoing.
Some are ongoing,
This is his,
and what have been the completed, what I have submitted before the authorities.
his self-declaration.
Yes,
Available on the, for, of the.
that's why I said you
available
have.
evidence.
Then your lordships may come to page 19,
Yes.
where it says proof of contracts related to maintenance of aquariums in government public sector undertakings along with duly filled annexure C. Duly filled is name of the department, period.
Yes.
So this I have given the details. My bidding has not given those documents regarding this completion. The reason being in the annexures it did say that you have to enclose them. That I have submitted before the authorities.
Yes.
So it is, yes, this is one of the particular work. This is supply, installation and commissioning. Your lordships may see 126. It's not the maintenance work.
No, I understand what you're
So, so far as the maintenance is concerned, I have also given these what I have done. And that proof is with the department. And they want to show this 126 and 127 as if this is the maintenance work which has been done. And saying that it's 3 months. So far as that 127 is concerned, has successfully completed the aquarium against work order, completed the public fish aquarium. That's the construction work.
Yes.
So the proof I have already given that has been not verified by the department. After verification by the department, the work order was issued.
Yes.
So if your lordships have any doubt so far as that is concerned, the department can only reply that whether I have complied with or not.
Yes. Who is for the departments?
Well,
And in the meantime, there is sort of development in this matter.
Oh.
And that's what you want.
What?
and the other writ petition, my lord, on the last occasion, my lord, for the honorable civil bench, I think that was also before lordships where the stay has been granted against this particular one.
Yes, last date. The date is over. I don't know what. If I remember correctly, I think it was 15 days or something. Fortnight, already more than a month.
Was moved to a single bench.
I don't know, my lord. I don't know who was moved it also. We have not received copy
I
also.
have no idea.
This is for procurement.
No idea.
No idea on that. I can have a look, man, I'll. I feel more happy. Can I have, thank you. So one could file for representation.
I don't know.
I had
We are
seen
not.
that order.
Because there was some interim order, that's why we did not start the work, because the authorities said there is an interim order.
Some representation was probably filed by.
No, maybe not. I don't know what has happened in the meantime.
Can.
What are you doing there? Why are you not taking a conscious decision if these kind of an orders are passed?
This is my lords.
And after receiving this order, madam, after
What? Then what? You are the state.
and notices are issued to the parties, madam, and they have reached the date of hearing.
Sir, are you not realizing that you are one of the orderly to uphold the law?
This was not brought to the notice of the signature.
That there is already a pending matter before the division bench concerning this.
Certain orders are also.
My lord, on the very first date without notice, it has been must have.
Order number
Maybe-
1.
There is another thing which is coming, which I have come across.
Day 1, I think.
That you dispose of the writ petition and pass an interim order. What are you doing?
To assist your lordship, subject to your lordship.
What assist? What you will assist?
No.
They have not disposed of the representation.
Till date.
So. What do you people will do?
I mean, this would be a different.
What difference?
Either. If he wants to remove his,
That is, so far as he is concerned, he has suffered this order.
This is, there's some, so we were under
Can't you
the,
take a decision? You are a agreed person by this.
no, we didn't know of this order in fact. It was only the authorities who said there is a direction, so we will,
Take a decision.
the authorities have to take it.
You have to take a decision.
All right.
Because they will not.
We will not.
Though the matter was, both the matters were substantially heard, Which order is in 9-6?
Lordship, as the request starts from page 58, Lordship. Annexure 5, page 57, but order starts from page 58, Lordship.
What is the dispute?
Lordship, in fact, Lordship, the petitioner, one of the participants in a particular action side, Lordship, Sanshira. And Lordship, way back, Lordship, his bid was rejected, and subsequently he filed an appeal before reduction before this honorable court. And by the direction of this honorable court, he filed an appeal before the appellate authority. And against the appellate authority, it was filed before this honorable court. And while considering the grievance and more special Lordship on the ground of jurisdiction, the order was set aside and directed to hear afresh by the competent authority. And it has been hard and peculiarly it has been dismissed on the ground of limitation. When there is twice direction of this honorable court Lordship, in first instance, I had preferred appeal, and that was disposed of with Lordship in a complete reasonable order Lordship. Lordship, for a moment, kindly see that order for first Lordship. Annexure 1, Lordship, kindly see.
What is the period of limitation provided for an appeal?
Lordship, that is 1 month, Lordship.
1 month. 1 month.
That is 1 month.
So condemnation application was also filed.
Lordship, and appeal already been disposed of, Lordship. Kindly see, it is Annexure 1, page 27. Page 27. Earlier, the appeal had already been disposed of. Lordship, can see page 27. That is on 37th and 24. Lordship, page 27, Annexure 1.
So the appeal was disposed of that the authority, competent authority did not in considering the limited prayer going through the order and documents of the come to the conclusion that Sangha has not rightly observed the formality as per the rule before going for selection.
Lordship, can you see the observation, Lordship, can you see just 1 page before, that's page 27. The finding was, Lordship, the perused to petition and the LCR received from the Tahsil Office, Bureau Matrapur, and other documents, during verification is found that the following formalities have been maintained.
No, I'm just trying to harmonize 2 paragraphs of the Annexure 1.
Annexure 1, Lordship.
If the appellate authority was of the view that
Is disqualified
that the entire thing has been done in violation,
in violation,
then why the second paragraph?
Lordship. That was the people of that order that was challenged before Lordship. Sorry, before this honorable court, Lordship. And Lordship, because of the jurisdiction, it was remanded to consider afresh, Lordship, by the competent authority, by the present Lordship appellate authority. Because in the meantime, law has been changed. Now it has been changed to the Steel and Mines Department. That's because this order was by the sub collector under the Revenue Department. Lordship, this honorable court directed to go and hear the appeal afresh, Lordship. And while considering this
order of the High Court?
Lordship, can you see at the next page? I have quoted the entire order. It starts from page 11. Para 13, Lordship. And the operative part, page 14, para 6, Lordship. Para 6 and 6.1, 2 paragraphs are there, Lordship. Page 14. Maybe, Lordship. No.
Operating portion is paragraph?
Para 6, Lordship. 6 and 6.1, page 14, Lordship.
So this, the appeal which was filed was really revived.
Revived, Lordship.
And it is to be heard.
Heard by the Lordship.
Correct. So
Now, Lordship, the appellate authority under the page 57, Lordship.
how can he go for the delay?
Lordship, they have only on the ground of delay, have ignored everything. And Lordship,
How can it be legal? This was only the order dated 13/8/2024 was set aside. And the direction was made that since there was a change of the appellate authority, record be transmitted and we hear out the matter. And then delay.
delay because the first order that was passed on 6/3/2023. There the direction was since the impugned settlement of lease is appellable one. This court is not inclined to entertain the writ petition. However, liberty is granted to the petitioner to pursue his remedy before the appropriate forum in accordance with law.
He approached the authority and the copy of the order dated 13/8 was there. And the authority, the other authority did not find any delay. And decided the matter on merit. And we can't make a reconciliation between the last penultimate paragraph and the last paragraph. At page 19. 29. I think a sensible man cannot make, how can we reconcile these two paragraphs?
Thereafter, another appeal was filed. That is at page 58, your lordship may kindly see. Page 58. Before the sub-collector fund post and the present appeal, which the order which is subject matter of challenge, your lordship will find at page 58.
Change of law.
Change of law. Yes.
Only record has been transmitted, lordship, for lordship's direction, lordship, this direction. So,
Here he has considered as per the limitations.
Sir, this revenue appeal, case number 14 of 2023 was registered on being transferred. Look at the first preceding or the preceding order of revenue appeal number 14 of 2023. So 2023 is that appeal which was disposed of on 13/8/2024 by sub-collector. And then how can you proceed on the basis of if the first appellate authority or the earlier appellate authority has decided on mandate, that means impliedly the conversion was done.
Last paragraph, time is some exercise here, the appellant has moved before the honorable court to final WT after lapse of 345 days. That is beyond the prescribed period of 1 month. The honorable court also did not consider the
Only the appeal records were transferred. So the appeal should have been heard in terms of the order passed by the
They
honorable
did
court.
not appellate our orders.
Yes,
yes.
I understand.
Amending of the
And power to condone is there on the appellate authority.
The power to condone not
Yes.
available under the rules. Under the rules, the power to condone on being shown a sufficient cause or other thing, that is not there. It is only 1 month.
No, has to. Where is the rule?
Your lordship may kindly see 46 of the Odisha Minor Mineral Concession Rules 2016. It's 61 of the book. Results. It will be the same book. It's 61.
In the Parent Act. Parent Act. Where is the Parent Act of 1927?
MNDR.
Where is the provision for the deed? Is there any provision for the deed?
Out of revision will be provided under fatigue.
There is an application for the appeal. You have.
But I have not annexed version, that is. First, I have the copy, but I am not annexed version.
It was awarded in favor of one Biranchi Singh. That was way back in 2022. The appeal was preferred by the subsequently.
2020, immediately thereafter.
23.
Read application, then read.
Yes, if your lordship will look at 46.5.
Writ petition or after writ petition?
After read petition, lordship, first read
Which
petition.
was filed?
Let's say appeal immediate, let's say Adjournment lordship. In 2023, lordship appeal file.
If your lordship will look at that rule 46.5. 46.5. Because lease was awarded in favor of that successful bidder.
No, before the competent authority, the approach was made within time. Where is the order of the competent authority?
The appeal at threat lordship.
46 says that any person agreed by an order of the competent authority.
Means lordship selection procedure, lordship, they have.
I just wanted to know that what is the order of the competent authority?
That for us, annex lordship. Let's say that is at lordship, kindly see at running annex a free series lordship.
This is what I just wanted to know.
Lordship, page 39, lordship, the last order.
This is what I wanted. This order is of 4/4/2022. Correct? Now, when you have said that you received this order was communicated.
Lordship, this order in page 40, Lordship, that is page 46 is the order improved, Lordship, page 40, Lordship, 40, that is on 8/6/2022.
Yes. This is issued to you.
No, not to the Lordship.
So the successful.
Suspend with the Lordship.
I am asking you your communication.
My communication, Lordship, first by of writ application, then immediately, Lordship.
In the writ petition, have you disclosed when you come to know of this order?
So in fact, that was the subject matter in earlier writ application. So the first instance, Lordship, I had approved this honorable court.
Sir, when you are moving here, please consider
Lordship.
what the appellate authority has said. He has said that from the date of the order, which is as far back as in the month of April 2022,
Lordship.
the appeal is filed in 2023.
23, Lordship.
But the rule 46 sub rule 1 does not talk about the limitation to start from the date of the order.
Lordship.
No,
Lordship.
it will start from the
The
date
date
of
of-
the communication.
Communication. Right.
I just wanted to when this order was communicated to you.
It was never communicated to me, Lordship.
So one has to say that it was never communicated to you, and when you come to know of this order.
First, then the subject that I have taken government in other writ application.
Then you have to interfere with this. Give us the factual before. Have you read 46(1)?
Yes, Lordship.
What it says?
Lordship.
And then of the date of the order.
No, Lordship.
Then
Any person agreed on the and order of the competent authority, Lordship. And may within 1 month from the date of communication of the order.
correct. So communication is very important. An order may be passed 1 year back, but it is communicated to you after 1 year. Then the
It is never communicated to me, Lordship. It is
Then that's to say that once when you come to know of this order.
I obtained the certified copy, Lordship, that
So you have to. Then this
circumstances under which you could come to know.
for the purpose of limitation, sir.
Lordship, grateful, Lordship. That
The certified copy, how did you apply? The circumstance and the application to.
Because in paragraph 2 at page, please come at page 59 of the impugned order. Paragraph 2.
Lordship.
Please come, this is what he has gone wrong. Paragraph 2. It says that it further transpires on record that even though the cause of action for filing the statutory appeal by the agreed person arose on 21/3, when this Virinchi Singh was declared as highest bidder, so that's scored wrong.
Lordship, grateful, Lordship.
Within a period of 1 month from the date of the said cause of action, yet no appeal. So wrong. It is limitation would run from the date of the communication, not from the date of passing the order.
Let me kindly see annexure 3. Annexure 3. That is the entire proceeding of the tender. Your Lordship, kindly see the order sheet 21/3/2022. The case record is put up today. On scheduled date and time fixed, the tender box was opened in presence of the participants. It was found that true number of lease application filed in the sealed cover envelopes by the applicant for Tarkias sand bed, details mentioned below. Kasinath Dhanwar is the present petitioner. True. And so also Biranchi Singh is the opposite part.
Correct.
So the additional charge so and so, Biranchi Singh, so and so.
One to be difference.
Yes.
Then
Found to be highest, it is pertinent to mention here that the other bidder, Kasinath Dhanwar, has not submitted the proof of payment of the earnest money with lease application, rather submitted a check and further submitted application fee. Therefore, the lease application of Kasinath Dhanwar is rejected. So he is aware of that.
once this order passed in presence of, this was the tender box was opened in presence of the. Now it has to be communicated. The order is not passed on the same day. I mean, at the same time, dictation in open. He says that it is dictated in open, I can understand. He must have passed subsequently. He simply opened the tender box. Question is, once you pass an order, you should communicate the order. Communication is very important.
Regarding communication, your lordship may,
Not communication to successful bidder, but communication
but to the
unsuccessful bidder.
other bidder.
Where is that?
Let me,
Then in paragraph 2 is wrong. Is definitely wrong.
let me verify with the authorities whether it has been communicated to the petitioner or not. To present petitioner or not.
I have annexed all those communications to, successfully, not to me, lordship. I have annexed the entire
Regarding,
cycle.
regarding this order,
Yes, but once you close the record, and then you annex all those orders,
Lordship.
then you are aware of those orders.
After,
So
lordship,
communication should not be restricted in that sense. Once you came to know of the order, that's the communication.
immediately I have approved, lordship. Immediately after obtaining this copy, second copy, lordship.
But
Immediately.
you approach the appellate authority after the liberty is granted to you by the court.
Lordship, that is there, lordship. I have approached first in deed jurisdiction, then lordship I have approached, lordship.
That is what is the problem.
Lordship.
And it was decided on merit.
See, merit, and lordship, people, lordship, can you see in the appellate of the order, he has admitted both the facts, lordship, that my,
This conflict, he has gone wrong, absolutely wrong. Against the spirit of the section itself. We show us one judgment, or there are judgments which says that if the appeal, which is otherwise time bound, is considered on merit, even if there is no order for confirmation, but it will be deemed that the delay is condoned. Or what the court or authority decides the matter on it. So later on, you cannot insist for
lordship, people, the outside, okay, because he has given substantial revenue, that's why this adjournment is passed. The other,
no.
in the subsequent also, sorry,
So lordship may kindly see the para one.
like, I got.
Take note of that.
I got,
Once an authority applies this man to marriage,
lordship.
it is deemed that he has confirmed the delay and
That's
so
all.
later on, once he enters into the marriage, the authority,
Okay.
later on he cannot revert back,
Lordship,
revert to the original position to say that it is bad.
lordship.
Here there was only transfer of records.
that is what I am saying. What he has done, that yes, it is transfer of record, but I find that the High Court was also ignorant. High Court also did not consider that there is already a delay. And therefore, exposition of law by him, very nice understanding of law, without looking into the provision of Rule 46, and he interpreted it, that the limitation would run from the date of the order and not from the date of the communication. He has missed that the limitation will start from the date of communication, not from the date of the order. And he has used the word cause of action. He does not know what is the meaning of the cause of action.
But in para 6, we have said that no application, no.
Is it required?
It is cannot.
Under section 5 of the Limitation Act, if you read, do you find any reference of an application to be filed under section 5 of the Limitation? You will not find the word application appearing in section 5 of the Limitation. Even on an oral prayer, if there are sufficient materials on record, the court can control. Where is it difficult?
Even
Give me that
otherwise,
judgment.
Lordship, I-
Read work,
Lordship,
do some exercise.
Lordship.
Give us the weapon.
Lordship. I've taken up those grounds, Lordship.
Go. Then you should come ready with the judgment.
Lordship, I'm not going through judgments, Lordship. But
Go.
that
You have
ground,
taken that ground.
para 38 Lordship.
After I put judgment of 89 once CHF is happened. And so 89 or 89 volume 1, it's in Calcutta High Court norms.
Perhaps this court has also
Page 33.
that if records could reveal honest of can be. So in absence of arbitration, also submission can be.
That is
By the court.
That is what I think will.
This
So arbitration is required.
It is one of this in RT. CLT. I greatly with.
Scum.
Yes, sir.
And this is an important factor.
Yes.
And he has gone wrong. He has not understood the meaning of the expression cause of action.
when we,
Bring no judgment, what is the meaning of the cause of action?
Cause of action.
It's a bundle of facts, not a particular date.
By affidavit and supplement Lordship.
What evidence?
It's all those factors I can supplement Lordship with judgments.
Just show us
Lordship.
what your first application.
Lordship.
The considering legal.
Lordship.
And bring those lines of the. Once the appeal or is decided on merits. Then the question of limitation cannot be reoperated. Section 3 of the Limitation Act has to be understood in that perspective. Consider
Monday, Lordship. Yes, sorry, I'm sorry, Lordship.
Item 9.
May I please, your lordship. May I please, your lordship. Lordship, the present petitioner is a C-class contractor, my lord. And she has allotted with the 2 repairing work and the said work completed since March 2024, your lordship. But the bill has not been paid to her. And the bill submitted by the JE to the assistant engineer, and they are sitting over the matter.
Where is the certificate of completion?
Your lordship, the
Certificate. That you have successfully executed the work or did everything.
Your lordship, I don't have that copy right now, your lordship, but I have given a representation stating all these things. That is on page 13, your lordship.
Next, your lordship will see his representation. He says, I have executed.
Executed satisfactorily and accordingly the bill I have. I'm a very fast reader, Mr. Das. That's so.
Well, he says, I have executed some building repair work. So
That's true.
whether it is partly, he has executed.
So you have to communicate, sir. You can't sit tight over the matter. Take instruction.
Well, this is on 21/6. He has
Yes,
made a
instruction 2 weeks.
Item 10.
Grateful, lordship.
Orissa State Medical Procurement Commission, the corporation, invited a tender for supply of ultrasound medicine machine with 4 probes, including installation and commissioning. Melody, also kindly see, I am challenging the taking a eligibility of the opportunity number 2 with the successful bidder. And there are only 2 players in the field. I am myself a petitioner and the opportunity number 2. Also kindly see the requirement. The requirement is first allotment is page 117. That is to be product and manufacture of quality standards. Let's see, page 117. Procurement. Quoted model should be USFDA 510K/CFG and EU CE certified. EU certified should be issued from notified having notified body number. My lord, also kindly see the USFDA certificate page which they have given. My lord, also kindly see that page 833. 33. Sorry, 732. 732. 732, that's the bit of it is the Philips ultrasound ink reference K182857. That is the FDA.
This would not get it. Just now I reached to 732.
Yes, madam. Madam, the company Philips ultrasound ink and the reference, this is US Food and Drug. This is US FDA certification, madam. So the number is K182857. The reference. 182857. 182857. Well, that is after that Philips ultrasound.
Oh, yes.
Reference.
182857.
That is the certification number, which they have given, the opposite number 2 has given. But this certificate refers to
one Philips company of Shanghai. That also document I have filed, my lord. Well, because that has to be, well, page 833 also will find. Page 833. Page 833. This they have not filed. We have got it from the website, my lord. Which they have got it, my lord. Tell us again.
A182-857.
No, this is the 7 my lord. And this is the establishment Philips Ultrasound Shanghai Code Limited. Establishment name. Because certification is given to a particular manufacturing unit, and that is the but what they have done, my lord, they have lots of kindly see. 821 lots of kindly see, page 821. 821. 821. My lord, kindly see. What they have given it, my lord. The declaration of Philips India, from which they have submitted the document to procure the machine and supply it. We may proceed, madam. We Philips India Limited hereby confirm that our product, that is Affinity 70 marking under Make in India concept from Healthcare Innovation Center in Pune from Chakan factory address manufacturing group. Well, and this doesn't have, this particular unit doesn't have the US FDA unit. It shows that how containing details of US.
Which for the other side?
Yes. Corporation is also appearing. Corporation is also appearing who has invited tender.
State-owned corporation, they are purchasing for the government hospital.
Yes.
It's a PS. My friend, I think. Yes. But all those, I think my learned friend is appearing in a PIL as a advocate committee and making allegations that machines are not being procured. Yes.
To that my answer is that my answer is that 2020 July 2023 that invited tender. And they have technical bid also they have opened in 2023. But till now they are not prepared.
Process is over. Purchase orders have already been placed since 1st of August. Is coming at a belated stage number 1. These are all ultrasound machines, and in the last week, Lord, a person died in Keunjhar, which is the home district of the Honorable Chief Minister. So this tender was not being finalized. So immediately I am giving a list of dates to our subsequent candidates. So Lord, in one hand, they are complaining that instruments are not being purchased, MRI, FMRI, etc. So that in one day, I called that managing director of medical corporation. We purchased equipments for SCB to the tune of 300 crores. They were rejecting every time it's single tender. I told, so what? Even if it is a single tender, there is no bar to settle it. That was exactly, I think my learned friend would agree to that.
It's not a single tender. Not a single tender.
No, not here. I'm giving example. So tenders may not were being floated abruptly, it is being intervened somewhere, stayed somewhere. So the patients ultimately were suffering. There is absolutely no bid. I'll produce the record. Sorry, no informity. Everything has been done. It's a two-stage bid, techno-financial bid. In the technical bid, there is absolutely no informity. I'll take instruction. You will simply call it some other day, but we'll file a reply to that. But no interference at this stage because these are the purchase orders since 1st August.
My lord, they are also purchase order. The tenant is also very clear. How purchase order will be issued? They don't what it
how it will be, after the settlement and the liquidity, this process is over. Now, on
22nd July, my lord, they have declared the bid, my lord. They have declared the success. 22nd July 25.
And we can't wait the patients to die.
L2 or
L2.
Page 15.
So, which make of ultrasound you offered?
We offered this US FDA you certified machine, my lord. US FDA certified, US FDA certified as per the NIT requirement.
Which company? The Philips company.
No, it is not Philips company. It is
Isote.
Financial bid will have
Question the company would make it input, not input. Important is the requirement because the technical expert body, they set the terms and conditions of the contract, the tender, because that is the.
What is troubling me is the concept of group of companies. Because it is clear that the Philippines is a multinational company. Its existence global. They have an existence in Singapore, they have an existence in India, they also incorporate the company, the control is with the parent company. And they incorporated one Philips India Limited in this country, just to make it, because the registration has to be done here. So Singapore is also there. So once they are manufacturing at one place. It is not that they are manufacturing at the different places. If they are manufacturing at one place, and if the certification is done by a country of their origin, then in that event, can be technical.
But in this case, my lord, the certification is as per the certification as per the manufacturing unit.
Ultrasound, NLP or LLC.
My lord, they cannot procure it from Shanghai because there is a bar set by the government of India Finance Department, because we have got
they have said this is a made in India concept.
No, my lord, that is a
technology. If the technology is one and the same.
My lord, dear lord, kindly see the page 915. There is a requirement of registration if the land, there is a land related, land adjacent land to the to India, my lord. Without land sharing, my lord, you cannot obtain from a country where we have got land sharing with India. Without valid registration, you'll have to register yourself, then only. There is a bar given by the government of India, and also that is adopted by the government of Odisha and the corporation itself also. That they take care bar, they cannot get it from any place wherever they want. And what they have shown, Melody, also page 915, Melody, there is a clear bar. That is the reason. And Philips India says that they are manufacturing here in India, not that they are.
Yes. Technology is a global based technology. And then say that this is making under the Make in India this concept the right now. And they have a factory so they say that you bring it.
No, that is not their case. That is not their case. And the certification, the certification. No, my lord, it is not the case there. Certification, my lord, US safety certification.
Lord, having participated in the technical bid stage was over since long, and having come out unsuccessful, it turns around.
US FDA
becoming unsuccessful.
No, unsuccessful. No, technical.
You can take a U-turn.
That if the successful bidder does not meet the mandatory requirement of a tender.
No, he's meeting the technical.
Come forward and say that how you have qualified.
No, that we have to respond. That we have to respond.
That is saying that the certificate which is mandatory in nature is issued by this US food such and such, where it is issued in the name of a Philips ultrasound someday.
No, correct.
It is not the Philips.
Let me
who participated.
Let the eligibility.
I understand this concept. That's why I say the concept of group of companies.
Right.
Although it is given to particular, because Shanghai has got, UK might have got, the USA might have got, or Singapore might have got, so separate, because they have to, manufacturing has to be done. 833 Lordship will kindly see the establishment, registration, device listing. The establishment,
Because
Lord,
of
those
occupational
factual
manufacturer, Lordship
aspects,
kindly see.
Lord, once the technical
The
committee has
establishment, Lordship,
scrutinized,
see, from eight
what is the
33.
basis of
Ultrasound
evaluation of the tender by the expert body,
Establishment.
that has to be stated. If we can
That-
file.
And we have brought it to the notice after immediately, soon after the
that has
executive is open, we have brought it to the
Right,
notice of
right.
the
It's not
authorities.
fair.
And
It's not-
and
it was
they
not- it was
remain
considered and
silent.
rejected.
They remain silent.
No, no,
And
silent. It has
yes,
been
they
considered.
no, they have not answered they have not considered, they have not answered my representations. When I pointed out all these things.
It has
to
been
the-
considered and
Not only
rejected.
that, there are several
Any
other
objection?
police are there. There is a volume navigation is there. When the technical demonstration, they could not show that level. That those things are separate. But Lordship kindly see this. That is the reason. 833 Lordship kindly see. If the establishment is there, so the certification relating to particular establishment, not that it's of the particular company. That is how the certification is granted, my lord. And there is a validity also for a particular period. That is the reason why they have given a false declaration that so they have given a certification number which relate to Shanghai, but in the bid document they said that we will be having from Philips India. How if the Philips India had the certification, they could have given the Philips India says why they gave that Shanghai and the Philips India also categorically says that we don't have a relationship with Shanghai. Philips India, that document is also there for lordship. And they cannot procure from China because of the restriction imposed by the government and which has been adopted by the government of Odisha. The document is there for lordship. And because my lord, it is big because it is related to the patients, my lord, the common sickness, my lord. So naturally, it is very important. It is very important. And it has to be done in accordance. The technical expert is that they have decided to have this certification. There must be something in that why they have decided this. This has to be and the machine has to be
decided
as per the tender condition.
Committee that is not up to it.
The other language that people are dying and all that those things are that is the reason why you have committed delay and we have participated in the tender.
Wants to make it further delay and will not allow.
No, I want that proper person should
let it come. We'll respond. Why do worry? We'll respond. The tender process is complete. Purchase orders have been already placed. They have supplied the machines. It is meant for the benefaction of the patients, and an unsuccessful bidder after opening of the financial bid takes a U-turn and proposes to challenge the finality of the tender after conclusion of the process. That is impermissible in judicial review. I will cite judgments. Your Lordship may, if wants to hear Milan, proposes to hear, will file a response to that. So all Milan vague allegations, he had filed objection that has been duly considered by the expert body, which is comprises Milan doctors and the persons those who have expertise in the instruments. Everything it is made for the benefit of the patients. 2 patients died in Keonjhar last week. So therefore,
the Philips India has declaration that they are not
no, my lord, we will produce the documents. Therefore, if there is any informity
within the India,
within it.
today.
Yes.
So once they are saying, even if their existence is to a bordering the countries, that
Right.
does not mean that their existence within the country can be ignored.
only that
They are not the company whose parent the organization is the bordering country.
Yeah.
They are from the Netherlands.
They're not from Netherlands. The thing is that, but this thing is that they have to, the Philips India has to have this US FDA certification. That is the unless base certificate, we cannot participate in the tender or the machine cannot be supplied. That is requirement of the NIT.
That's a big question. So far as the other computer related matters are concerned, it's if one of the companies is pioneer in this regard, as its existence in a developing country, then no purchases would be made and no operating system should be allowed to operate within the country. I think it will close down the entire company.
But the thing is, also, the NIC condition has to be strictly followed, and the NIC condition has not been followed.
They have already declared.
Yes.
They are not procuring this from the ordering country.
Yes.
They have their own factories within the country.
That is my case.
And they are manufacturing here.
That is my case, my lord. That is my case. Because then, that is my case, my lord. If they have, they will have, the lordship can, they must have the certification, FDA certification authorized. Please have patience. My friend, please have patience. My lord, US FDA certification has to be there with the Philips India, and then only they can supply, my lord. And the opposite party number 2 can.
Do you have a certification from?
From US FDA, from US FDA certification, that is that is that. Is, my lord, 462 page 462 Lakshman Kalisi.
That's certificate.
462.
यूएस बंद कलानी आमर आमी बंद करूछु एबे आपण देई परिबे
Alert mechanism. Yes, certification is measured. Certification number. Diversion and the sort of SPA. USFDA organization is the certifying organization. They will certify ballot.
Giving the certification.
USFDA is giving the certification. Page 190 Lakshman Kalisi. Page 190 Lakshman Kalisi for a minute.
justice
Ballot, my declaration, the petitioner's declaration, that name of the manufacturer, this, my declaration is that it is manufactured SOTS, PA, and country of origin is Italy. Country of origin is Italy.
And their country of origin is
India. They say that they are manufactured in India. They don't.
They are not a company.
Original company. Origin may be from within the land, but
what the chicken?
Yes.
They have these also abroad. Their existence is global.
Yes.
So they may be in the bordering sharing country. They have their existence there also in this country. Everywhere in other parts.
Different parts of Procedural.
What they do it. Now, that is the only thing that you can't say that they cannot.
Certification. No more. I don't know. Cannot certificate. Certification.
Common man, common public. You are also relying on authorization. You have also given us certification. Somehow it's not matching.
No, the certificate. Establishment melody, the establishment term, establishment is there. The certification which they have given of Shanghai established is the other they would not have given. 833 melody. A particular establishment melody, Lakshman can listen. Page 835 melody.
Just show me the certificate.
Yes, 833 melody. Page 833. 732. 732 is the declaration. 732 is the declaration, my lord. Yes.
You showed me that.
Yes, I'm sorry. Oh, I'm extremely sorry, my lord. Page 32. 732. 732.
Those who stand here, it's not the fourth vote is there.
Yes, that is the, so we are separate.
Say they are not a complete property to issue.
No, they are the competent authority to issue.
Now they are issued in whose name?
Whose name is Philips Ultrasound Inc. Establishment name is not there, my lord. But that establishment, my lord, your lordship, the establishment relate to the 833 document I have seen, my lord. The establishment they have given the 833, my lord. Why I am showing 833, lordship, kindly see. Establishment registration device list. That is also there. That is also, lordship, kindly see. This if that certificate relates to Shanghai, the Philips Ultrasound Shanghai Co Limited. The establishment 833 makes it clear. Registration number is same 182857. Okay, 182857, and that relates to that document I filed. The document they have not filed. They have filed it because I have got it from the website. This certificate doesn't relate to Philips India Limited, and Philips India has to obtain them. This particular number has to be granted to Philips Ultrasound Shanghai Co Limited. That is available from the website. Certificate is always given to the establishment, not a particular company. I can understand if the gratuity is given to the where they have got manifest unit throughout the world, that is a different issue. But this is not the case here. It has to be given to the establishment.
US.
Yes. Yes, US FDA is the authority.
Because they have said that the existence in Buffalo.
That's the parent, that certificating agency. That is the certificating agency. Or Philips Ultrasound is the company.
That's the care of Mr. Mark Job.
Yes. 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 Establishment, you know, the establishment name is not stated in the which they have filed, but establishment name will also will find. Yes. We'll also said that this
number, and you find that it relates to the same Philips company, but registered as a
registered under not company, but it's not a.
I think the country is sharing a border with us.
Sharing border with us. No, it is not a company, not certificate, not given to the to particular individual establishment, certificates are given. For each, because that has to be, each establishment has to conform to the requirements of that 833 or some kind of 833, that is there.
Yes, no, so that's why.
Not only that, we have
certificate cannot be used universally. That means every organization, according to him, must have this cycle planned.
Organization is the plant. Each plant has to get that certificate.
Please allow me.
Please, I am only answering.
Not allow it. All right, do submit.
Allow this as an India limited company.
And we'll respond once. Just a minute. Let Monday may be too short. Your lordship may call it at least a week after. Let me discuss with them. Let the technical committee was evaluated 2 weeks ago. Let after the opening of the, I am on the maintainability also. After opening of the financial bill, when he came out unsuccessful, it's a settled law. Please don't interrupt Mr. like this.
Sorry, please.
I didn't notice. See. Every moment, all right, let us have respect for each other. Can't be intersay argument. That it has been supplied.
Because after all, it concerns.
It's a yes,
right, exactly.
Every day they are making complaint by the advocate committee. He is a member that equipments are not being purchased when we are placing on.
Don't listen. But only thing is that we wanted that if you come.
That's correct. Let your give a yes.
Monday.
See.
Monday and Friday, I'm begging your lordship's indulgence, but I'm appearing in
Come on Tuesday.
Tuesday.
That is
Tuesday. Let it come, no issue. So we have to, at today's not, I'll get there. Sir. 13th Pillar, your lordship may call it on 13th. Yes, no issue. Yeah. Deep replies. The lordship recollects I have filed a preliminary objection regarding misrepresentation and fraud initiated by the petitioner. This is your lordship. There are two aspects your lordship to bear in mind. And if a person comes to the court with an
You asked him to handle only the stay order. But my colleague in court will hand over the stay order.
no, let me address, please.
No, I'm not interrupting. I'm just bringing to the court's notice that there is a stay order and my colleague is there in the court to hand over the stay order.
I'm assisting Mr. Freedom.
You are. This company is controlled by whom?
Well, it's by the board of directors.
What's he saying?
He's Mr. Mrityunjay Mahapatra, he's been authorized to sign by the.
Who is controlling?
Controlling in the sense.
Who is controlling? Who is the main?
They'll have it's a public listed company, they'll have their own shareholders.
Yes. Who is the majority shareholder?
That I'll have to assess.
That what we did in the evening itself, we have already suspended two officials with the senior and immediately transferred the director of mines and geology. The purported certificate was issued by the gentleman, and we are proceeding to transfer everybody whosoever was in that mining section, director, joint director, deputy director, everyone. It's a clear fraud, and 696 crores the dispute is pending. Unfortunately, the senior who was appearing, he was representing the state. I am filing the orders one after another.
You're getting the shareholding.
It's a fraud on the estate.
Ashok Parishar. Where is the first stay order? Ashok Parishar, Advocate General is appearing for this. Oh.
Of the last 20%. You have to meet what the views is saying. 10DC, order number 3.
My lord, I'm not able to hear your lordship's question. My lord, the Chief Justice's question. I'll try to answer if your lordships will be so kind as to repeat the question.
My lord has asked the question, who is the?
He just got it.
We're just ascertaining that, my lord. So it's of the last audited and annual accounts. We're just. My lord has asked, put the question, who controls the petitioner company?
Yeah, it's like the input is for the input. And this is not for the central. Info versus normal report, this is what I was. This person has filed a petition. Input of questions.
It give us.
You have no authorized person.
The representatives of the company, but
They
You
don't
can't
know.
hold. You can't find.
they're also pulling out the exact schedule.
This
We've
is
asked them
what-
ask them for instructions.
There is also judgment of Delhi High Court Justice Srila 1980.
Not asking the question to me. He's not asking the question to. This is for which?
So just awaiting instructions. We get by.
We have to use them. Print out credit card Philippine.
Questions, what a shareholder will become.
No, you should ask me now.
Let's just send instructions to Mr. Learned Senior who's leading us, he will respond.
He's speaking. You can respond. I think there's some lag. He's waiting for you to respond.
No, he's switched off his quarter, switched off its mic. Milord, may I respond to your lordship's question, or may I make my brief submission?
Yes. What is your response?
Milord, I understand your lordship's question is, who are the principal shareholders of the company? Is that your lordship's question? I'm sorry to...
Yes.
Yes. This is a public limited company, and there are several shareholders who are also corporate entities. For example, I have a list of shareholders. One company has 15%, one company is 10.82, one company has 7.48, and Life Insurance Corporation has 6.34. Then there are various companies which, according to my rough calculation, owns about 60% of the company. It's a public limited company. There are individuals also who are shareholders. It's a widely held public limited company. That is my respectful answer to your lordship's question, if I have understood the question correctly.
I think the information which I wanted is not, I'm not getting that.
May I respectfully ask your lordships?
That is what I really wanted. You can.
If your lordships repeat the question, I will certainly try to answer or gather the information.
Who is the controlling person of the company?
This is the Jindal Group. Jindal Group. There is a gentleman who is the head of the family, and he is perhaps the managing director or so. And then maybe one or two other members of his family are directors. I will get the board of directors' names. I will get the names of the board of directors. But may I say something else, my lord?
What?
That this demand is data based on instructions. I'm saying this. This demand
Mr.
is
Chidambaram, what I feel is, let this
Yes.
matter be taken up by another bench. It's better let it be taken up by another bench.
No. I'll certainly appear on another date, but just to please give me. Oh, another bench, my lord, your lordship saying?
Yes.
Oh, I mean, that's entirely,
Fraud directly on the exchequer. Not only that, 696 is the disputed, sorry, the pending litigation. 900.
Because the difficulty is, I do not want to repeat the question because he is appearing virtually. I do not want that everybody should know.
It's a serious matter. It's a clear fraud on the exchequer. But your lordship may hear it.
Oh,
Some may not, at least some people should get the message from this court very clear and loud.
my lord, may I, your lordship's order is final. If your lordship's.
Taken action without against 5 officials.
No,
IAS officer.
that is the privilege of the state.
Yes.
I have nothing to say.
Clear collusion, if I submit further, I will file it on affidavit. How
If
this
the
is-
learned advocate general
But there
will,
is no whisper in the petition.
if the learned advocate general will permit me to
Yes,
give
of
3
course.
dates.
It's my duty to protect the state. and
We had some other.
Your lordship is,
since one of us in my
Yeah.
team is not inclined to take up this matter
very well.
on a personal ground, let this matter be released from this bench and be placed before the Chief Justice for assignment.
When will it be placed?
Item number,
Is your
I
lordship
did not-
giving a
I did not
particular
notice
date?
the
my lord?
name
Is your
yesterday.
lordship's giving a
I
particular
did not
date? my
notice
lord?
because I normally do not go into the party's name. I just go into the matter.
No, absolutely,
And yesterday
absolutely.
night,
just-
when I was reading it, that's why
Yes.
something stuck
No,
in my
no, your
mind.
lordship, my lord, the chief justice is absolutely correct. If your lordships, I just want to know whether your lordships are giving a particular date or it will come in the order
No,
later.
immediately it will be, file will be placed before me in an administrative side and
Very
it will be assigned to another bench today itself. Don't worry.
Very well. Obliged, my lord.
Blood take note.
right,
Blood that is a part of the record, the preliminary objection.
No,
We
take
have
back,
to
take back. We are not taking it. Take back.
right.
It's called the.
Item number 12.
Let the impugned order annexure 1, page 15. Passed by collector may not. Essential.
Item 12.
Yes. Essential in the grievance area. Under the scheme of rules, Rule 53, with regard to sifting. An application for sifting is to be submitted and it is to be allowed.
Where is 26/7/2025 order?
But that is at page 15.
What we have done.
The collector here has deferred consideration of my application with the precondition that the petitioner be directed to deposit the whole area at MGQ. And thereafter only the application shall be considered. Shop, as per the collector, shop was closed on 1/7/25. It's a house landlord and tenant dispute. We can say tenanted premises. And despite the agreement was over, somehow or other since 23 this shop was running, but should not have allowed to run. 23 agreement expires, but this shop was allowed to run. But the last renewal, Excise authorities passed an order that by 31st of March 25, you shift the license, otherwise will not allow further. That your lordship would kindly see. That is at page 27.
Page 27, Annex 3. Your last renewal is up to 31st of March 2025. Kindly see the endorsement subject to shifting of the shop. At the top of this right hand corner of this page. 205.
Yes.
Now, obviously, my lord, even if from 1/7/25 the shop is closed, the petitioner will be liable for that. My lord, I cannot say that petitioner is not liable because petitioner himself closed it down from 1/7/25. State is no way concerned about the dispute between landlord and tenant. My lord, but from 31st/3/25, state government imposed a condition that unless you shift it, will not allow further renewal, and further renewal has also not been allowed. Now, I applied for shifting before that date. That's its admitted position and case. On 14/11/24, we have applied for shifting, my lord. That date your lordship will find from the impugned order itself. 14/11/24, we applied for shifting. Now, it has taken time up to 27/3/25 to process the application and resolve their internal matters with regard to report, inquiry, and all these things. Now, collector at this stage is passing an order that you pay the whole from including that 33/3/25 till date for as a precondition to consider your application for shifting. That is the order passed by the collector. Now, my humble submission is apparently collector's order is appellable. This order, in fact, if it would have been a final order, then I can go in appeal. Now he has kept my application pending with a precondition to deposit for the whole period for which the government itself passed an order that will not renew your application. Now, this order, if your lordship would kindly see, I can understand I am asked to deposit from 1/7/25 to 31st/3/25. That he has to deposit it. Now, this amount also, Lord, if your lordship will consider, there is an in an identical situation, there is an order passed. Can I show it to my lord? Lord, in this order, honorable court has not decided anything with about to liability or non-liability of the deposit. They have only deferred it to be considered by the appellate authority, but on acceptance of current dues, they have allowed. This is a case where shifting was allowed, but here shifting has not been allowed. This is a case your lordship holding. Shifting was allowed, but he was being asked to deposit the whole previous period. Now, the honorable court passed an order that on acceptance of current dues, you allow him to run in the shifted premises.
Go and file an appeal.
Lord, subject to if your lordship permits this, my lord, because otherwise the shop is closed today. Lord, here the lordship can see two things are there.
No, the provision is still there. You are within time now.
No, it's not now within time. But one thing just I request my lords will kindly consider. My shifting application which is deferred.
First thing that so far as the total demand is concerned, it cannot be said that there is no demand.
No, cannot be said.
Demand may be up to 31st of March 2025. They have to segregate. It may not be full amount, but some amount. It has to be deposited without which you can't.
But accepting the whole period also. Without joining issues with regard to even from 31st of March till the date of construction. But because it's a shop closed. Even accepting the whole period, I'll be liable to pay, my lord. What I'm just trying to request, my lords, kindly direct the authorities to consider the shifting application on payment of current amount. These things they will decide, whatever they will decide, I'll abide. Current is, my lord, I have deposited shifting fees, whatever amount, false consideration advance as a precondition for grant of license. Whatever decision they will take, I'll abide by it. That is what in fact.
They have raised the demand of 90 lakhs.
No, not demand has not yet been raised.
Yes,
Yes, no, I'm sorry. I'm sorry. Yes.
This is what they say.
Yes, they have said.
Shortfall.
But that is what they have said.
We can't do it. If you deposit the whole amount, they will consider.
This deposit period, your lordship will kindly consider.
That's why I say that your contention is that my license was valid till 31st of March. And thereafter it was not renewed. And I could not operate.
Yes.
Then at least my liability should be up to 31st of March. So let them determine what should be the liability up to 31st of March.
Yes.
And then you are ready to deposit that amount. Plus, if there is any further requirement of the deposit to process the application, then application will have to do process.
But that I have deposited. And current whatever from the date of shifting, whatever is the liability, I'll go on paying. But this amount, I am also not denying. If they are at all decide to direct me to pay this amount, I'll pay in a phase. pay in a phased manner subject to direction given by the whole subject to deciding this liability.
So that's why there are two options for this. Either we can direct them to calculate the amount with 31st of March 2025, let them calculate to deposit that amount.
I'll deposit that.
And thereafter, if any, under the rules, if any further amount is required to be deposited,
Yes.
for a posterior period, that is from 1st of April,
Correct.
we'll have to deposit.
That if they decide this way. Because that certainly I'm not troubling my lords to take that burden. Subject to they decide, keeping in
35 of the Odisha Excise Rules, 2017.
Rule?
35.
Yeah.
Page 87, if my lordship is holding the same book. So lordship may kindly see Rule 35. To whom license or exclusive privilege for sale of intoxicant not to be granted. Licenses or exclusive privilege for the retail.
That is the disqualification.
Yes. Shall not ordinarily be granted. Then your lordship may kindly see B1 is in arrear to the government.
that's a dispute to be decided by them. In an appeal to be filed by
That
them.
is a precondition. Now the license has not been renewed.
What should be the area? The area is the period within which you work, and if there is any demand, how can you raise a demand for the whole of the period?
Yes.
Why not up to the validity of the license?
My lord, if your lordship may kindly have a glance to that impugned order that is at page 80.
What?
Page 80, the impugned order. They have para 3 of that impugned order at page 18, 1A. After due inquiry, the Excise Inspector Sadar Katak submitted his inquiry report on dated so and so, and the shop could not be shifted during 2024-25. In the meantime, financial year 2024-25 was over, and the licensee failed to lift 2479.16 LPL of IP.
What we say that
Yes.
they will definitely lift in the current year.
Yes.
They will make up the shortfall. Yes. This is a consistent view of the court.
But
But can you say that there is an area? It's a non-fulfillment of the lifting conditions. That they have to lift this much of IMFL and this much of PL. Whatever. So if they did not, then that will be case have to make up. That is what the consistent view we are taking.
yes,
Then in a continuous years, they not only they will lift this much, but also the shortfall they will also.
yes.
So but apply and take a decision. How can you keep that decision?
But his application is for
Mr. Das
shifting.
will complete.
So
I am again saying, if you go by a very strict literal interpretation of the words used in 35 your bill, it talks about a formal licensee. When he made an application, he was not a formal licensee. He was a correct licensee. He was continuing because he made an application in the month of November and the license was valid till March next year. So he cannot be regarded as a formal licensee.
And their own gazette.
but the SOCOS was
I am absolutely not, I take it.
but
These
this
conditions are attached to a formal licensee, not to others.
but he was issued with the SOCOS after completion of that period on 29/4/2025. The SOCOS was issued.
When he becomes a formal licensee, but his application for shifting, if I correctly understood what he argued, was in the month of November 2024.
Yes.
Yes,
When this validity of the license was there,
yes,
so
2024.
he can't be regarded as a formal licensee. And if he is not a formal licensee, then B and subcategories that does not come under 35. You will consider the application as on the date when it was filed.
Yes.
Here, my lord, the application was filed on.
November 2024.
Yes.
And just interesting one, just page 81, the state government has issued a gazette notification under the Public Services Act that the all sum applications shall be processed for opening within 60 days. They have given the timeline and they are keeping it pending as a precondition to all these things. Either you reject it, then we'll go above. And collector has no power to reject. It is the commissioner only to decide this application. So point of jurisdiction also I have taken. Collector is
What to do? 35 will come. The law. Please do one thing. We are directing you to just give a calculation.
Yes.
The collector is directed to recalculate the amount which is due
As on,
the first of March.
yes.
See, we direct him to deposit that amount and we also direct him to consider the application. And in the event you allow the shifting, then in the event she will get.
Everything will be done.
And make up that shortfall in the.
everything I'll do.
You can do it. That will be a condition and don't renew.
Yes, yes.
If it does not, then the minimum guarantee of the past year and the current year, then at the time of renewal,
Don't do it.
further renewal.
Lordship, then grant me some time to produce that calculation before the fourth time.
The petitioners,
They have, in the impugned order, they have also referred to 34.6.
I have not made.
Yes.
Otherwise, certain more remarks will be, I have seen 34.
34.6.
I have seen one. So I do not want to make it.
May I please, Your Lordship? The petitioner has submitted a tender for level 2 transport contract for the district in 3 units, ma'am. His tender in the technical bid has been cancelled on the ground that the petitioner has in the year 2023 has filed a writ petition before this honorable court challenging the rejection of his tender and allowing the ineligible person. For that reason,
Since you have closed the court.
yes, my lord. Your Lordship may see the additional affidavit I have filed because I got it later on. They have not supplied it. I got it on 5th. Your Lordship may see.
Document.
B, my lord. Flag B, your Lordship may see.
Yes.
Flag B, the additional affidavit.
I am opening it.
My lord, page 5, your Lordship may see. Disqualified bidders. 1. Joy Durga Transport. I am Joy Durga Transport, my lord. Sri Jyotiranjan Board, proprietor of Joy Durga Transport, applied for L2 operation at Jotani Block, Jotani Municipality and Khordha Municipality and Bhubaneswar Block. The said firm filed a case against OSCCL Limited by WPC number 21851 of 2023, which is still pending before this honorable court. Thus, the applicant has not allowed to participate in the above 3 units under clause 5C of the condition of disqualification mentioned in the tender paper protected by OSCCL Limited for the absent. Your Lordship may see. 5.6 as page 30 of my brief, my lord. 30, my lord. 30. May I read, my lord?
Please appear for this OSCSC.
No, I have instruction to appear.
That is a remedy provided under the statute.
No.
Other, I go further higher under the constitution.
No.
Can that be? There's a counter program. Society has opposed the remedy or court for a remedy under the law.
I cannot
Be taken as a negative point for him.
No, let me just only clarify one thing. And this clause 5.6 doesn't speak of a case for which you will be barred. Any dispute with the OSSC or which operation is
No,
found
it
to be
does not
unlawful.
talk about the case. It says that if there is a dispute between the OSC, can you?
A dispute doesn't necessarily mean a case. The decision that has been taken is by the DLTC, which is headed by a collector. So the state is, so far as DLTC, your Lordship will kindly consider the operation. The corporation only gives a model.
I am simply asking you, sir.
Man.
There may be an existing dispute. The dispute must be originating from your end. If the person will succumb to you, is it
No, it is not like that.
unequal bargain?
My dear
You
Lordship,
are in a commanding position, so you can impose any condition which is unconsignable.
this condition was there in the previous 2
I
tenders
do not
also.
want to, it has been brought to our notice. Can you? Can there be any clause or in a civilized society which is governed by the rule of law, a person, if he has approached the court for ventilation of his rivers, then he is debarred from participating.
It cannot be. It cannot
And
be.
his candidature, his bid, everything will be rejected at the discretion of the.
Absolutely not.
Then.
That's my submission.
Then.
But what I humbly beg to submit, I just, if your lordship permits me, the DLTC has divided him by saying that there is a
I
case.
just wanted, there are 2 weeks.
Right.
If he has already been blacklisted.
Right.
And if he has challenged the order of blacklisting.
Right.
And if there is no stay order he has obtained.
Right.
Then what you say is correct.
Right.
No, but that was not according to him, it was not a case of a demand.
No, absolutely not.
Then.
I'm not saying so far as the DLTC decision rejecting his bid on the ground of pendency of a case cannot be a ground. Because I am assisting the court also. But 5.6, in my humble submission, doesn't speak of that pendency of a case is a debarment. 5.6
Is of any dispute. Suppose, sir, there is earlier contract. He has worked, completed successfully, raised the bill. Now the authority is you, means your authority, says that no, this is the excessive bill. He writes, no, this is not an excessive bill, this is in accordance with the conditions. The dispute has arisen. He is not agreeing with the officer's step. You reject his future bid.
But that component.
He can't raise, he can't put his case.
May I just clarify one thing? This clause 5.6 contains 2 components, namely.
I'm concerned with the first component.
Exactly, your lordship. So
concerned
therefore,
with the first component.
your lordship, so far the first component is concerned, the example matter your lordship has just given may be a valid matter. For example, he says, I will get 5 rupee, the corporation says you will get 3 rupee. But that will not be a ground to debar. But the other part is whose operation.
We don't agree, and the person went to the court saying that I'm
that decision.
He's not paying.
Let me just clarify. Corporation has not rejected the bid, but in terms of the.
Then who has rejected
the DLTC headed by the collector. DLTC headed by the collector.
Yes. How? Under what circumstances you care? Sorry, then the question was the wrong person.
They only refer to clause 5.6.
That's true, and that too disputed by them because they have gone to the court. Everybody has a right. There's a constitutional right guaranteed. Can he not? Can he not? And assert his constitutional right.
DLTC ballot clerkship is right.
No.
DLTC.
Who is the person?
Referring to that clause as passed this order.
Who is the person? Who has passed the order?
And the committee headed by collector for that.
We direct all the members of the committee to remain personally.
Thereafter, they have opened the price bid.
All the person to remain personally. The second clause.
Second ground, it is for 1 unit, my lord. They are saying I have not stated in that unit relating to the go down where I have to shift.
You have to sit means
I have to transport the commodity from that go down. The go down name, it should be RRC and DSC. He has stated CWC.
And there is no CWC.
No CWC, my lord.
So,
so it is for 1
ground is provided by them.
Yes, my lord. They have given a chart from where I have to transport the commodity which place. Your lordship may see the tender documents. That chart is there, my lord. Your lordship, page 57, your lordship. That is for 1 unit, my lord. I have participated in 3 units. They rejected on the ground of filing of case for all the 3 units. And for 1 unit, I have made a wrong statement relating to, your lordship may see page 57. There a chart has been given where from the commodity will be lifted by the contractor if he will become success. Jotani block, second one, from CWC Jotani. And Jotani municipality from RRC from DSC Jotani. There he has written that CWC Jotani.
Yes. Now, so far as this district is concerned, then what to do?
That mistake cannot change the guideline also. My submission is that because they have already given where from I have to live and where I have
You
to.
have applied for the 1 unit.
No.
Which unit you applied?
I have applied for Jotani block, Jotani municipality.
And what you have said,
Lifting in respect of Jotani municipality and Khordha municipality.
yes. So what?
They have stated RRC cum DSC Jotani. And the petitioner has stated CWC Jotani.
Okay, it's a CWC Jotani.
CWC Jotani there is for Jotani unit, my lord, not for Khordha municipality.
Yes.
There is a unit, Jotani unit is there, my lord.
No, I am unable to understand
My
what you are arguing.
My lord, you are saying, my lord, no, my lord, I am not able
You
to.
are taking me to page 57.
Your lordship may
This
see.
is the general information.
A general
The
information.
first block is name and location of RRC.
RRC.
Then
CWC.
says the name is RRC cum DSC of
Manchester.
Mancheshwar.
Or Bhubaneswar municipality.
For Bhubaneswar.
Municipal. Then second one
CWC Jatni.
for Jatni block.
Jatni block.
Block.
So you have written CWC Jatni.
No, my lord. What I am saying that CWC Jotani has been stated in place of Jotani municipality.
Where is the Jatni? The Jatni municipality is
Third one.
next
Third
That
one.
will be RRC cum DSC.
DSC Jotani. That is, I should have written RRC cum DSC Jotani instead of CWC Jotani. And my submission is they have fixed a point where I have to live.
But will you not check your document when you submit?
My lord, it is a mistake on my part. I cannot say about that Jotani municipality, my lord.
So, and there
With
is
other
that
two.
in case if there is any error.
My lord, that I do admit, my lord, there is a mistake on my part in respect of one unit, my lord.
So 1 unit.
Yes, my lord. Other two units they have voted.
Left.
For Jotani municipality and Bhubaneswar block, my lord.
How do you do it? There is the rejection of.
My lord, page 4 of the Part B additional affidavit. Page 5.
Item number 20.
Item number 20 leads to the 73 4B of the final payment. 20 as well as 22 months.
Item 21.
Also, in this case, the petition is challenging the order of past the state is city. Hyderabad, but open number one, wherein the delay, this this has not been confirmed. Which one?
Also, basically, yesterday, since reaching the popular not and similar order part by the honorable bench. Necessary correction of the.
Yes. Yes.
23.
23 is cancellation of GST law.
Item 24.
Annex 6 million. As from the left, page 32, the 11th table, the order portion, it's 45 million. Paragraph 20. But it is now unequivocally established that the petitioner is entitled to receive both interest on the delayed payment of gratuity as well as transactions for the bank account, which has been wrongfully withheld. The withholding of the gratuity without payment of interest constitutes an infringement of the business law of the entitlement.
Your other side. Are you ready for a final hearing?
Yes.
Are you ready for the final hearing?
It's not question. Yes, sir.
Gratuity amount is to be paid on the date of hospitalization. If you do not pay, then are you not liable to pay?
Yes, sir. Then I agree, sir. But your lordship can have glanced. What happened was before this followed the order imperial honorable builder passed an order followed 1/3/2024 at page 26. Allowed to sit in a branch along with the petitioner and to settle the matter amicably. Thereafter, my lord, the bank paid a sum of 1,09,000, and after that, the petitioner filed an affidavit under Annex of 4, stating therein that towards the delayed payment of gratuity, she has to receive only 24,807, and towards PF 2,18,000. So in sum and total 2,44,000. That affidavit that was brought on record, and but while passing the into judgment order, Honorable Singh, that affidavit has not been taken into consideration. While directed to pay a lump sum compensation of rupees 5 lakhs. My response is that when the affidavit was there, pursuant to the order of the Honorable Single Judge, the bank and the petitioner sat together and they decided to pay rupees 1,09,000, and pursuant to that, the petitioner filed the affidavit that she is entitled to 2,44,000. Honorable Single Judge, without taking note of this affidavit, directed to pay a sum of 5 lakhs. That is only.
Yes, what is this affidavit?
The fact must be just before my lord, so that this will have great bearing on the amount of lump sum amount granting of the
What do
petition.
you have to say about this affidavit which you have affirmed?
That was when the discussion was there, bank did not agree except payment of gratuity interest on the road. They did not accept my views. So the matter could not be
Why
decided.
why you affirm the affidavit?
Because on that day, what has happened, that I have given
and only gratuity portion, with delayed payment, they have paid 1 lakh something instead of more money. And about arrear salary, they did not agree. About the bank's contribution, they did not. So my may kindly allowed to say the facts. The deceased of the widow, respondent, he was working as a peer at Eco Bank, Andhra Pradesh. And his date of appointment was
Yes.
he was appointed on 12th September 1980. That's what his salary. The terms of appointment was that candidate writ application annexed to 3. Annexed to 3 case paying of writ application. There, they have appointed the peer.
No, so they did not agree actually on that day. This affidavit is what they wanted to say, that I have not agreed, I have not been paid.
She has not paid, my lord, towards PF. That PF amount is 2,18,000. That, my lord, the bank will agree. But he's saying that, my lord, besides this 2,44,000, she has anything, my lord, to from the bank, my lord. That is not that. Then you also can have glanced to the affidavit.
Where she has said that she has no other remarks in the affidavit.
The affidavit, you also can say annex of 4.
Please, I am looking at the affidavit.
Yes, ma'am.
Read it.
Yes.
Please. It does not say so that she has abandoned the right.
No. That because, my lord, the husband of the petitioner, my lord, approached this honorable court after being superannuated. And the bank, my lord, as per the lordship's direction, the bank, my lord, paid 17 lakhs some odd, my lord, towards my lord, leave salary, etc., and retirement dues, my lord. After getting the 17 lakhs some odd, the husband of the petitioner did not, my lord, approach the honorable court second time. After death of the husband of the petitioner approached this honorable court, my lord, with prayer, my lord, to pay some other reliefs, my lord. And during pendency of the petition, the honorable single judge directed to sit together and settle the issue. And after that, my lord, the bank paid towards delayed payment of gratuity 1,09,000. Therefore, after getting this 1,09,000, the petitioner filed this affidavit that she has to get 24,000 some odd towards delayed payment gratuity and rupees 2,48,000, 38,000 towards PL. So at best, my lord, she is entitled for 2,38,000 and 20. At best, 2,44,000. That is the affidavit. But honorable single judge did not take a note of this, my lord, payment of rupees 1,09,000 and this affidavit shown in by the petitioner, directed to pay some amount of rupees 5 lakhs. What I only submit, my lord, even if she is entitled for that PF amount, then she will get 2,44,000.
Fact is different. Fact is, the peon joined the bank on 29th September 1980. Basic salary was 245 rupees. Same basic continued till the date of superannuation. No annual income was given. He was not confirmed in spite of several correspondence recommendations from the branch to general office and head office. They did not consider it. Result is, as he was not given confirmed, provision account number was not given. So members' contribution not recovered from the employee's salary. He did not get any increment till date of superannuation 2014.
What she was doing from 1980 to 2014, that's a long 34 years.
In spite of bank's own rules,
I'm asking you why your husband, when he was alive for 34 years, he did not assert his right.
The bank is
approaching the court.
The branch has, he is approaching the branch. Branch has recommended several times to confirm me to head office. Kindly see my rejoinder.
But whatever he,
they did not give. That is their
But
high-handedness.
then why you did not, why your husband did not approach the court?
At that time, they have said, this is
So if you
Yes.
sat over your right for all the time and after
that
supervision.
is the bank responsibility to confirm him.
Come with this.
Then another thing,
Let us come ready on the other day, we'll see to it.
my lord,
See to it. Fix it on Tuesday.
their bank's contribution plus real salary, which they have paid less, all these things they have compensated by the.
Matter listed for orders under the heading withdrawal. Item number 33. Item 33. Yes.
You find?
I number 12887, para 2 minus. During pendency of the request, withdraw.
Yes.
Item 34.
Go. Yes, sir.
Opposite party number.
Item number 35.
The batch of cases, we have filed an IA application to withdraw, including the decision of the government not to proceed with the.
Each case I is there. But may I come back. Item number 25.
I've been instructed today to appear in the matter. And I seek little accommodation.
Next week.
Item 26.
Cannot finish within 15 minutes.
May I suggest one thing?
One thing,
This time is given and the date is fixed for hearing.
Date is fixed.
So from 2 PM, this matter, this bunch will be decided.
Minor, you also fix up any date.
Monday. We haven't opened your lodging, so.
Yes.
The operation of the judgment.
That's the problem. We are on AVA.
only
We
thing,
want to be heard before
I
your
have given a
lodging.
bunch of judgment there. You want to substitute, make a index and giving it. Can I take
Is it
it?
true?
Yes.
So that you will also come ready.
Yes.
I have given yesterday, my lord, to
A bunch of judgments probably
I don't-
on
I
record,
don't
because it's scanned and they're there. If you actually permit, I would point it out, or I will.
No, let us
Supply a fresh.
I have
hard
not
copy.
to complete. Many things are good.
First day.
But the difficulty is that.
The operation of the judgment is at least till that day.
First day.
What is the ultimate decision which is?
Down
They tell
to
the issue.
20th.
Yes.
I have filed an IM. I have filed an
Provisional
IM.
list, and that will finalize on 12.
Because it's only a provisional.
Pursuant to my lord's stick care.
It will not be finalized. The
My-
objection has come.
No, objection last week.
Last is 12th.
The next.
So after the objection has.
Because they are in such a.
After the, thereafter.
They are going in.
They are going.
Its mind to rule out the objection,
The-
accept the
the
objection,
problem-
whatever.
Yes, sir, you are so correct.
No difficulty.
Pursuant to my lord's, that honorable civil judge's order, they are now in a lightning speed, they are moving. We are now in the next of, yes. My lord, we
Yes.
You just look this.
Take care.
Till the objection is there.
Yes,
We are fixing this matter for hearing. Yes, final decision you take it. But objection you go on
receiving. No filings. Oblate. Oblate.
My only concern is, I let this matter be heard on Thursday. I mean, it should not look like as if the operation of the judgment has been stayed. That's all.
No.
We are not saying.
Yes. Even
I
on
am not saying
ADC,
anything on
yes.
that. Bunch of the rules. We listed on the.
Serving the copyright.
Milos, may please direct him to serve me as well, Milos. We have not received the IA he has
It's very
filed.
difficult actually to serve you on BC because you have the beneficiary.
No, no.
Eventually,
Milos, I will reach out. Milos, no difficulty.
PDF form, you give the PDF form.
Yes, Milos. I'll be grateful.
Give your reason.
Soft copy I'll send.
You have appeared.
Item 28.
Grateful.
I am going to respond. 228 days delay. 228.
What do you want to do?
Let them give the copy of the appear. And let's say 1 week time, let's grant fix some other day so that.
Yes, 1 week.
Let's kind of fix it.
Yes.
Item 29.
29, my lord, there is
A copy of the
99.
different sir.
I'll already, sir, in course of, in course of, yes, sir.
29, sir.
29, there is a delay of 299.
Please for anybody is appearing.
I'm appealing on.
Behalf of the respondent,
Yes, madam.
the takes service of notice. And takes service.
Yes, Lord.
Item 30.
Because there is the judgment was delivered in the
How many
petition.
days delay, sir?
Well, the delay is technical about 1 year, but I have filed the review. After disposal of the review, I filed.
Does it arrest the period of limitation?
No. So that time I have taken the standard that is there. Just time.
No, you should, you are an officer of the court.
My-
You know the law. Tell me that filing of the review stops the period of limitation
No,
of
no, no.
filing an appeal against the case.
No, man. That I am not saying.
So you.
No, sir,
have
that is-
notice,
no, not 1 year, but less than that. Just I-
whatever notice,
Nice.
one day creates
Yes,
a right
yes.
into the other
Other
side.
I'll take note.
Notice, 2 weeks.
Item 31.
Position. How many days delay?
Must.
2 weeks.
32.
File reports.
These two men are delay of 30 days.
684.
There is delay of 30 days in country.
Yes.
There is delay of 30 days filing the. I will take notice, but at the same time, your lordship, Mr. P.R. Barik, advocate, was appearing before the honorable single judge for the opposite parties. No. May be permitted to serve a copy of Mr. P.R. Barik. So that
I do not know if he is not there, then what can be done?
the whole difficulty, there is a allotment or not, I will be nowhere.
No, then why you were delayed? Or you could have immediately approached the court within the period of limitation. If you have caused the delay, then the right has accrued.
In fact, Manoj, what is that?
What can be?
The
You are
orders
showing
are
a
being
concern
uploaded.
that if I am directed to give a notice, I am out of court. Why you came belatedly?
Because
If
some
you have,
situations, my lord,
if you have consumed so much of time, wait for another 2 weeks service.
Man. Item number 36.
Fix up a date so that.
Item number 36.
If it's the government had to take instruction.
PIL for illegal slaughtering of cows. So.
Only see the last order dated 3/7/2023.
In fact, I need.
Government had to take after instruction.
What?
Order number 34, dated 3/7/2024.
Madam, English order.
Yes, sir. Madam, in this order, we directed to file an affidavit whether cow slaughter is banned in the state of Odisha or not, Miller. So that effect, yesterday we have filed an affidavit, Miller.
What?
That it is.
There is already, there must be a law.
Yes, Miller.
There must be a prevention of or a prohibition of the slaughtering of the animals. That
Yes, the law which is there, it's already settled. That's the which says that
54 or 56.
19
there.
Yeah, this is 1960 here. The state, it's a state act. It says that the cows cannot be slaughtered, provides a blanket ban for slaughtering of cows, and provides certain exceptions in case of a bullock. So
the cow is included in the schedule animal, in the schedule.
yeah, I'll take your lordship to page number running page 79. In fact, the act has been annexed there. Running page 79, running page 79. The act is the Odisha Prevention of Cow Slaughter Act 1960.
Well, this is the.
79, your lordship. 78, it starts from 78. The entire act has been annexed and
It has been paginated also.
No, from where you got it? So the act does not contain the pictures and all.
No, it does not contain.
The order,
I'm looking at.
the relevant provisions have been quoted in that order dated 3/7/24 in para 6.
That's order number 34.
Yes.
Order number 34. Paragraph 14 and 15.
There is a complete ban. On the top. Then what is happening? What is your problem? You said you filed a counter yesterday.
Only affidavit.
What is the affidavit? What you have taken?
Affidavit for not in the report.
Only point is there in para 10 of the order, let us kindly see. The competent authority has to be notified by the government. The question is whether it has been notified, so that we will give a certification of this thing. What type of cows have to be slaughtered or not?
Not cows. If cows cannot be slaughtered, it is only the.
No, cows means the entire.
The bullock.
Yes, that is right.
They say that it should be fit for such purposes.
Yes. So that notification.
The competent authority is not notified.
That has not been notified. That is why the instruction was struck from the government. But he says that the file and affidavit, let him give the copies to us so that we can assist your lordship also after going to that. My lordship will apprise no doubt.
Why paragraph 9? Why paragraph 9? Where is 64?
We are satisfied given whatever that is done, but so far the competent authority is also required.
Where
for
is section 4? Can you have the copy of the? No, I'm really in a fix when I read paragraph 9 of that order.
Yes.
Section 3 gives me a clear the other idea. Why paragraph 9?
Municipal Corporation. By 62 of Municipal Corporation 2003. That bans cows. 562.
That is to be read with the act. That is the state.
Yes, that is there. Paragraph 16 is very clear. Now it is banned. Yes, complete ban. Now the competent authority is to be. Yes, what do you say? That's a very small one. Yes.
Well, file an affidavit, well, probably that affidavit is not linked with record.
What you have said.
Impact on the law.
Sir, you have read it, sir. You tell me what you have said. Have you taken steps for appointment of a competent authority, or you have not taken steps for appointment of the competent authority? Tell us.
Steps are not taken.
Not taken. We are issuing the mandamus upon you to take a steps within a period of things. Yes, 16 days is complete ban.
No, that's 16.
Yes.
I thought it was.
Yes, it's a course of complete ban.
Complete ban.
Cow slaughtering is banned.
So far as the bull or bullocks are concerned.
Yes.
Form of obligation concept.
There is no difficulty. But bull or bullock. For that, the competent authority has to be.
Now, how good product and application we submit the authority. This has to be clarified from the.
No, the cow is a complete, you can't touch it. Not even for any other purposes. So far as the bull or bullock is concerned, there is a chance, but there is a mechanism which is already provided. Is there any rules which is framed on the basis of this act? 66. Have you said that what are the procedures which have to be followed?
Have you elaborated, elicited the morality? Have you elaborated, elicited morality? No, no, no.
That it's not notified yet.
The instant public interest litigation raises a serious
Not sorry, but no, 55. It is 55 of the interim order, it needs to be continued. There's an interim order in Act 55, it needs to be continued by government. State was that, yes, sir, 55. State was directed to file a counter, no counter has been filed till date.
Counter?
We'll file.
You want extension?
Yes, sir.
Extension, time to file but we will stop it. Interim order. You extend it till the.
Item 44, my lord. I made a.
Pleading is complete, my lord. And the interim order is against the me, my lord.
So can you
No,
give me
no, I
10
pray
minutes,
for
10 minutes time, so I will come again and sit and we'll take up all those matters seriously. If you give me 10 minutes time, I can come. No, that's why I'm serious. That's why I'm saying I'm not.
I'm just mentioning my item
Next
56 and in the morning.
It will be too tiresome for your
All
lordship.
those matters are so huge. Everybody wants to argue. In one of the matter, anyhow, I could fix the matter on a particular day so that I can.
My problem is that tender will end on August and your lordship had directed them to take instruction and file counters. It has come in the after notice category. In fact, no notice was issued. Your lordship seeing the
which one?
Item number 56. 54. 54.
54. Take it on Monday.
Item 44, your lordship. Very sorry, my lord. As your lordship said, morning I made a mention. My lord, I was debarred for 2 years. Now it is 1 year is already over. And there is no fault, your lordship. Only for a typography.
We have, I have, but rather we have the reward as you said, yes, you can go through it.
My lord. Let it come tomorrow, my lord. I have only prepared a 2 pages written note. I will not take more than 5 minutes time. Let it come on.
Keep it on Tuesday.
Yes. If